So welcome to this public hearing for the committee's inquiry into the Road Transport Amendment Medical Cannabis Exemptions from Offences Bill 2021. I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are meeting today. I pay my respect to elders past, present and emerging, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. In our first and only hearing for the inquiry today, we will be hearing from a number of stakeholders with an important perspective to share on the bill, including cannabis researchers, representatives of medical cannabis users, road safety experts, advocates for prevention, and legal organisations. We will conclude with evidence from the New South Wales Government. I thank everyone for making the time to give evidence to this important inquiry. While we have many witnesses with us in person, some will be appearing via video conference today. I would ask for everyone's patience through any technical difficulties we may encounter. If participants lose their internet connection and are disconnected from the hearing, they are asked to rejoin the hearing by using the same link as provided by the committee secretariat. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's hearing is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about comments you may make to the media or to others after you complete your evidence. Committee hearings are not a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. If witnesses are unable to answer a question today and want more time to respond, they can take a question on notice. Written answers to questions taken on notice are to be provided within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Finally, for those participating in today's hearing by video conference, can I please ask everyone to please state their name when they begin speaking, to speak directly into the microphone, and to mute their microphones when they are not speaking. In terms of the audibility of the hearing today, I remind both committee members and witnesses to speak into the microphone. Finally, could everyone please turn their mobile phones to silent for the duration of the hearing. I now welcome our first witnesses. If each witness could please state their name and position title and swear either an oath or affirmation, starting with Dr. Joel Wren, who joins us by video conference.
Thank you. My name is Dr. Joel Wren. I'm the current president of the Society of Cannabis Clinicians Australian Chapter, local chief executive. Solemnly, sincerely, and truly declare that the evidence given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Professor McGregor, would you like to go next?
Thank you. I'm Professor Ian McGregor. I'm the Academic Director of the Lambert Initiative for Cannabinoid Therapeutics at the University of Sydney. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Dr. McCartney?
Hi, my name's Dr. Danielle McCartney, and I'm a research fellow at the Lambert Initiative for Cannabinoid Therapeutics within the University of Sydney. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Great. And Dr. Arkell.
My name's Dr. Thomas Arkell. I'm a research fellow at Swinburne University in Melbourne. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Great. Thank you all for joining us today. Would you like to start by making a short statement? And if statements could please be no more than a couple of minutes. Dr. Wren, would you like to go first if you have an opening statement?
Yeah, absolutely. Thank you. So as stated, my name is Dr. Joel Wren. I currently work as a GP in Southern Adelaide, though I also work as a telehealth clinician servicing patients Australia-wide. I thank the committee for the opportunity to provide a clinical insight into this issue. I'm here to advocate on behalf of the thousands of patients in New South Wales accessing medicinal cannabis products legally, and to show that the current punitive approach to detection only of THC is nothing short of discrimination. Every clinical decision holds so many variables such as primary indication for intervention, concomitant medications, living arrangements, liver capacity, and kidney function, just to name a few. Impairment is an important social consideration. I counsel patients about psychotropic effects of opioid analgesics, antidepressants, hypnotics, and anxiolytics. I advise them to avoid using machinery, including motor vehicles, if they feel impaired. As a legitimate emerging therapy, medicinal cannabis and the driving laws that surround its use need to be consistent with other prescription therapies currently available. Prior to any questions being asked, I implore the members to reconsider replacing medicinal cannabis with other current medications prescribed widely on a daily basis, such as benzodiazepines or opioids, and it will quickly become apparent just how archaic these laws actually are. Thank you.
Great. Thank you for that. Professor McGregor, do you have an opening statement?
Yes, I do. Thank you very much. I represent the three of us in this opening statement. We're all biomedical researchers with a strong interest in medicinal cannabis, and that extends into running clinical trials with medicinal cannabis products, developing the medicinal cannabis products of the future in our drug discovery paradigm, but also doing a lot of policy work and outreach work with patients in the community. And I'm very proud of the efforts, particularly of my colleagues here, who've done some of the best international studies recently on the issue of cannabis and driving. The reason that the Lambert Initiative is interested in this area is because we hear from patients all the time in our outreach work what an issue this is for them. This is, in many ways, the number one difficulty that medicinal cannabis patients face. And this problem's not going away because we're anticipated to have maybe 300,000 medicinal cannabis patients in Australia by the year 2025. Our own work and the work of our colleagues internationally shows that the crash risk with cannabis does go up, but it's a very small amount and relatively tiny compared to other drugs where you are allowed to drive, particularly opioids and benzodiazepines, as Joel mentioned. So there's a bit of a double standard at play that concerns us, and I think we can use our science in a very wise and informed way to develop a much more refined policy around medicinal cannabis and driving, and I would invite you to explore the evidence with us this morning and examine what that refined policy might look like.
Great, thank you for that. And Dr. McCartney and Dr. Arkell, you're fine with that opening statement? Great, thank you. So we'll start now with some questions from the committee members, and who would like to, Ms. Fairman?
Happy to go. Thank you, Chair. Thank you all for appearing today and for the very important work that you all do. I might start with you, Dr. Wren. You suggested that if there was a replacement of medicinal cannabis with opioids, we'd quickly see how archaic these laws are. I think that's something along the lines of what you said. Could you expand to the committee a little more about why replacing opioids, why replacing medicinal cannabis with the opioids is a bad idea in your view, in your opinion?
I think that the rash risk with medicinal cannabis, as has already been pointed out, is wildly overblown, and the issue is that we are widely prescribing these medications every single day to many Australians and we're telling them it is okay to wait a while if you feel impaired, that some people do metabolize these medications differently. And with medicinal cannabis, it's just a flat-out refusal, absolutely not. It doesn't matter about any sort of impairment, it's just based on presence. And from what I see, it severely restricts the access to legitimate medicinal cannabis products, which has been repeatedly highlighted in multiple inquiries, including the Federal Senate inquiry, I believe, from about 2019.
Thank you. Might just to take a step back with maybe the researchers from the Lambert Institute and potentially just assume a level of knowledge about the benefits of medicinal cannabis for people with, you know, lots of different ailments. Maybe don't assume there's a particular level of knowledge in terms of this response, if that might help. So. Why, Professor McGregor, you said you hear from patients, you work with many patients of medicinal cannabis, you hear from them the difficulties they face. Firstly, what type of ailments, what type of people is medicinal cannabis helping? Let's just start there, and then I'll get on to a question about the difficulties they face.
Yes, well, we crunched the numbers on that quite recently and published a paper on the first 5 years of medicinal cannabis availability in Australia, and we went down to a granular level of detail in terms of the conditions being treated, and about 60% of the prescriptions are for people with various forms of chronic pain. So that would be back pain, neck pain, arthritis, fibromyalgia, so on and so forth. So that's by far the largest category in terms of conditions being treated. Then we see anxiety, and certainly the trends are upwards for the treatment of anxiety with medicinal cannabis products. And there's an important technical point here that some of you are probably aware of, and that is the difference between a THC-based and a CBD-based medication. And about a quarter of the prescriptions going out at the moment in Australia are for what we might call CBD-dominant products. And CBD is a component of the cannabis plant that doesn't intoxicate whatsoever. But it seems to have strong anticonvulsant effects in epilepsy, and also there's emerging evidence for a range of mental health conditions that it has quite dramatic beneficial effects, and we're doing a lot of work on that. So a really important point, and this is from Danielle McCartney's work here, that CBD does not impair driving. Danielle published a paper on that just last week, which went viral all around the world, and Tom has also published on that with vaporized CBD. So you can say that for a quarter of the prescriptions, there's no concern around driving whatsoever because these are CBD-dominant prescriptions. And the current drug testing regimes used by the police in New South Wales don't get a false positive with CBD either. Danielle's also shown that in another very useful practical study. So the concern is mostly around the 75% of prescriptions that are for THC, and they're for chronic pain, for anxiety, increasingly insomnia as well. A range of sleep conditions are being treated with THC medications. And that's also very relevant to driving because these are typically taken at night. So there's an important question which we've answered in a recent study, which is if you take THC by night, are you okay to drive in the morning? And the answer there was resoundingly yes in a paper that we haven't published yet. So yeah, a wide range of conditions. There's more than 130 conditions that are currently being treated with medicinal cannabis products, more than 250,000 prescriptions, more than 4,000 prescribing doctors, and the trends are all ever upwards. So this has become a mainstream medicine, and that exaggerates even further the need to deal with the driving issue.
Can I just check on the conditions? Is there something as well about, like in the laws governing the prescribing of medicinal cannabis, that other other medications, medicines have to have been tried first or aren't effective or don't work. Is that correct in New South Wales?
Yes, generally that's the TGA guidance. I mean, our clinician colleague here could probably speak better to that. Joel, is that the yardstick that you apply?
Dr. Wren?
Yeah, absolutely. So under the current legislative framework, because almost all of these medications are unapproved, unregistered medicines, applications must be made to the TGA for really to state that conventional therapies have been trialled and have either been discontinued because of adverse effects and intolerability or just it being ineffective. So initially that must be tried before then seeking approval for medicinal cannabis use.
Sorry, Professor, the percentage of patients using the THC, I presume, what percentage of those are cancer patients, particularly end of term in palliative care?
Yes, that's certainly in the
Increasing?
Yes, that's all of the conditions are increasing, and treatment of cancer symptoms is certainly in the top 10 of the list. We did an interesting clinical trial. We were part of a trial at the Lifehouse here in Sydney where patients that were receiving chemotherapy and experiencing nausea and vomiting that was resistant to normal medications used for nausea and vomiting were given a THC-containing medication to see whether that gave them some relief from their nausea, which is very common in people getting chemotherapy, and that showed a highly significant and beneficial effect of the cannabinoid medication. Recruitment in that study was actually very difficult because of the driving restriction. These patients were told, sorry, you're not allowed to drive for the duration, for the several weeks of that trial, and we estimate that about 50% of patients or potential recruits to the trial walked away for that reason.
No, I had a close friend he's passed away since, but the only thing that helped him, particularly feeding and nausea, was the medicinal marijuana. But again, he couldn't drive.
Yes.
All right? He says, I feel fine to drive. There's nothing there, but even if I'm outside that area, I can still get picked up and pinned.
Yes, that's right. I was talking to Phil Donato, who some of you may know, a member of the Senate here, I believe, and the member for Orange. And we had a chat with an oncologist based at Orange who likes to prescribe medicinal cannabis to his cancer patients and runs clinical trials out there as well. And the story was basically the same, that there were many patients who would love to be trialing medicinal cannabis for their cancer-related symptoms who were unable to. This is a particularly acute problem in rural and regional New South Wales, where driving's not really an option. It's just something you have to be able to do.
So the THC level, how long does it take? How long does it stay in your system for you to be picked up?
Well, I should refer this one to Tom Arkell. You've done the study with the police drug testing.
With alcohol, we know what the alcohol range is, roughly how long, but what about for the THC?
It depends what you're measuring it in. In oral fluid, which is obviously what roadside drug testing uses, it's highly variable. For a lot of people, it can be gone within a couple of hours. I've been running a study over the last year with patients down in Victoria, and I've seen that some people are still testing positive the following morning, so somewhere between 10 and 12 hours after they would have last used a dose of whatever product it is that they had been prescribed. So it can vary a huge amount. It's very hard to say exactly how long it stays around in your system for, particularly in oral fluid.
Alcohol is the same, it's different for different people as well.
Yes, but because it's eliminated from the body at a constant rate, there's a pretty good relationship between the amount of alcohol you consumed and how much you have in your system, and that's why breathalyzers, that's first of all why BAC limits work very well, and secondly why we can use breathalyzers widely, because we know that relationship between how much you've had and how much is in your system is very reliable.
Just on that, Dr. Arkell, in the New South Wales Government submission to this inquiry, which I'm not sure whether you've seen that, excellent. They state in that presence of an illicit drug in oral fluid is reflective of recent drug use. But I suppose what you're suggesting is that statement is not entirely true or is slightly misleading. It may be reflective of recent drug use, but it may also be reflective of drug use at some time past. Is that correct?
That's right. It tends to indicate recent use. The reason for that is because when you have THC in your oral fluid, what that is simply a coating of your mouth from when you've actually consumed a cannabis product. So if you inhale it, that vapor is coating your mouth. If you were to take an oil and you drop it under your tongue, that's also coating your mouth, and that's what's being picked up when you look for THC in oral fluid. If you look for it in blood, it's sort of reflecting circulation in the body, so it lasts for a bit longer. Urine, it can last for months in some cases. So oral fluid has the shortest window of detection because it's simply reflecting what's actually stuck in your mouth.
I mean, I suppose, the government is using that line. They're making that statement to suggest that people who are testing positive at roadside mandatory drug testing, those people have all used THC recently, and that is what is being picked up. But you're suggesting that that just isn't actually accurate, that there are people who are testing positive at mandatory roadside drug testing who have not recently used THC.
It's very possible that THC can be present in your oral fluid for longer than you're impaired for. It's also possible that it's present in your oral fluid and you're not impaired at all. Now, that's not the case for everyone. It may be for some people that it does reflect recent drug use and it does reflect impairment, but it's not reliable. It's not a reliable indicator of impairment.
Thank you. Perhaps to you, Professor McGregor, also, you cited research that you had done, and your submission talks about research that you'd collaborated with international colleagues in relation to the crash risk of people who have consumed THC. Again, in the government submission, they suggest that evidence cited by Monash University finds that THC can increase crash risk by around 50%. So I wondered if you might address that, because again, obviously the government submission is that it's very dangerous to drive after you have consumed THC, and therefore this very punitive, zero tolerance, presence-based blanket rule is appropriate, and that's the sort of evidence that they're suggesting. So I wondered if you might respond to that based on the research that Lambert has done.
Yeah, I mean, I must say we were quite disappointed with the New South Wales government submission, even though it cited a couple of our papers, which was nice. which was nice. But I think the interpretation thereof was a little bit off, and there was some logical inconsistencies, I think, in that submission. We also have reservations about the recent work of Muirk as well, which I know Danielle's been running a ruler over their latest studies, and there are legitimate concerns there. The crash risk data are complex. These are large epidemiological studies. It's very hard to get a highly accurate and refined methodology that will give you an exact number in terms of the enhanced crash risk with cannabis. But the best controlled studies are telling us that what we call the odds ratio is about 1.1 to 1.4 if you are acutely intoxicated with cannabis. So that's, in other words, it's an increased crash risk of 10 to 40%. That is about the same as 0.04, 0.05 blood alcohol concentration, and it's significantly less than you would see with opioids or benzodiazepines or sedating antidepressant drugs that are very widely prescribed. So that puts that risk in perspective. The other really important point to make there is that if you're a regular user of cannabis, a daily user, then your driving impairment seems much reduced. You develop tolerance to impairment with driving. So one of our assumptions, and this is yet to be studied in a proper clinical trial, there are basically no good quality clinical trials that have been done with medicinal cannabis users and driving, but our assumption would be that the crash risk may indeed be minimal, if not negligible, in people who are using cannabis for medical.
Because they are using it regularly every
Because
night,
they're
as
using
you
it
say,
regularly.
to manage pain.
But also, if you're alleviating a medical condition, be it insomnia, or pain, or spasticity if you have MS, then these are conditions that will impair your driving anyway. So if you take a medication that relieves your pain, relieves your insomnia, relieves your spasticity, then that may actually improve your driving. And we've got a shameless pitch in our submission for a study that we'd love to do.
Yeah, so that was my next question, the AMBER trial. Perhaps, my colleagues will have, I'll throw over to my colleagues in a tick, but that would be my last question just for now. Can you just give us a little bit more information about what your pitch is? This is the opportunity to make it to the New South Wales government about supporting that, because clearly the lack of comprehensive evidence, because cannabis has been an illicit substance, it's been very difficult to do a lot of research involving it. So what does this particular trial look like, and what would you be interested to see from the New South Wales government in support of that?
Yes, so I think we've certainly made a mark internationally in terms of our driving research. Tom over here did a world-leading study using actual on-road driving in the Netherlands, where people vaporized cannabis and went for a 100-kilometre drive in a specially instrumented Volkswagen, so we could get a very refined picture, and maybe Tom will speak to that in a little while. But we've also done a lot of work with driving simulators. So to resolve this kind of legislative problem, if you like, and it's certainly a major problem for patients, a major practical problem for patients, what we really need to do is gather data. And that is to take a whole bunch of patients, say about 150, who are initiating medicinal cannabis for the treatment of, say, chronic pain. And we'll give half of them the actual cannabis that they want and the other half a placebo, and this would probably be an oral oil. And then we'll track their driving performance over the first 12 weeks that they take their medication. And we could do that one of two ways. We could do that in a driving simulator, so they come into our labs and we look at their driving, say, every week or every couple of weeks and see how they're going. And the simulator is of very good quality and correlate very well with on-road driving. Or we may use a gadget that Tom has been telling me about, where we can put this in their actual cars and measure their driving ability over time. And there we have it. It's a very simple trial. We just look at their driving when they initiate a THC-based medicine, and we have a run-in. We look at them at baseline. Then when they go to the medicine, be it cannabis or placebo, and then we've answered the question: is their driving impaired by that medication, or isn't it? And our strong belief is that if there is an impairment, it will probably be in the first week of treatment, and that it will abate over time, and then by week 12 they'll be driving just as well as they did without their cannabis-based medication. But you're running across the passion of scientists here. This is how we answer these questions, not with political arguments, but by gathering data, and we'd love to do that study. Unfortunately, the Lambert Initiative is well funded from our philanthropists, but clinical trials are expensive, and we never have enough money to run all the clinical trials that we'd like to. So we'd love to join with the government, actually, in running this trial if there were a possibility to do so. Maybe there's a little bit of money sloshing around at the end of the financial year in New South Wales Health.
I'm happy to keep going, but my colleagues.
Yeah, I've got a couple. I've got one or two questions as well. So, and then I'll hand over to my colleagues. In terms of measuring impairment versus measuring a sort of historical or past presence, what methods do you have to do that? In terms of, when the police do breathalyze, motorists, that obviously there's a difference between what you were saying, Dr. Arkell, about, people who may have previously used cannabis but aren't currently under the influence, but how do you actually measure impairment?
Danielle, you've written the book on cannabis impairment recently.
I guess in our studies we have a few different ways. As Ian's already referred to, we use our driving simulators and we have computerised cognitive function tests and a few sort of high-tech gadgets like that. Obviously, not all of that is as practical at the roadside. And so we do need to be looking at alternative technologies, I think, that can be used effectively in that setting. There are a few different options that are sort of being researched, I guess, at the moment. We've done a little bit of work using computerized apps. So, for example, you can put a fairly simple cognitive function sort of task on someone's phone or a similar sort of device and measure their impairment within the test that we've been using. Takes about 2 minutes. So it's quite quick, and they're in the process of validating something like that at the moment.
What's the name for that again?
The Druid
Thank you. Yep.
task. Yeah, that's the one that we've been using. I believe that there are others.
Yep.
There's also research going on looking at using all kinds of different technologies. I know that there's some eye tracking sort of work going on, and I think that's something that's going on in Tom's lab, looking at how you can use people's different, measure people's eye movement and behaviour and things like that in order to ascertain an impairment. And then beyond that, there are, of course, the field sobriety tests and things like that, which are still widely used internationally in order to identify people who are not safe to drive. So there are a lot of options. There's a lot of work going on this space. There's a lot of room for improvement. But that's certainly...
Well, I think that obviously that all sounds incredibly interesting and lots of very important technology that seems to be developed, but in terms of actually being able to roll it out to police officers in terms of detection, it seems like it might be difficult to do that at this current time, compared to a breath test, which is easy and already being done for alcohol consumption. Is there anything that could be rolled out easily and practically tomorrow to measure impairment, as opposed to, a sort of previous presence, if I can put it that way?
At this stage, I think we're still looking at field sobriety tests.
Yeah.
It's still widely used, the old walk and turn and things like that. I believe they're used in the US, things like that, to detect impairment, Canada. But yeah, do you want to?
Well, one very simple task which has been shown, at least in one study, and we'd like to do some work on this, is something extremely simple, and that is can you stand on one leg and close your eyes, which sounds a little bit flippant, but there's at least one study that suggests that's very difficult to do when you're acutely intoxicated.
Can you just repeat what it was? I was just distracted for 3 seconds. What was it?
Yes, so part of the normal field sobriety testing at the roadside in the US is there's things like walk the straight line. That doesn't work well with cannabis. People seem to be able to walk the straight line quite well. But if you ask them to stand on one leg and close their eyes and remain upright, that seems to be quite challenging. Tom, is that your understanding of?
Yeah, the only other thing I suppose I would add to that is that some people find that very hard anyway.
Yes, exactly.
And if
Just say on this if you finish.
I would say particularly in older people, where your balance, tends to get worse, particularly if you have hip or knee problems. And if we're talking about a 75-year-old who's using THC for chronic pain, it may be that they can't balance anyway. So there's some, I suppose, limitations in terms of, while it appears to be more sensitive than some of those other tests, it is, true for some people that their balance is probably going to be bad enough anyway, that whether they've had THC or not, is probably not making much of a difference.
You need a baseline. I think that's the problem with these functional measures of intoxication, that everyone starts at a different level. So to see whether someone's impaired, you need to know what they look like when they're not intoxicated. As Tom points out, it's a big difference between a young, fit 18-year-old athlete versus a 75-year-old with
But you see
severe
the problem,
arthritis.
though, that if you were to remove the standard breath test or saliva test and then not replace it with anything, then you could have a situation where it could become quite unsafe if you're not measuring it in some other way. So, you know, it's all, there has to be some sort of alternative to just removing the standard breath test used by police officers. Wouldn't you
I think the
agree?
intent of the legislation is an exemption for patients. It's not to remove oral fluid testing
Yes.
entirely, and that's a different argument.
Yeah.
I would say that other jurisdictions, and we mentioned this in our report, seem to be able to manage these exemptions without much of a problem. And I know the New South Wales government submissions seem to find it incredibly difficult to the mechanics of an exemption, which I found rather strange. Surely it's just as simple as ascertaining from the person's physician that they have a legitimate prescription.
No, I understand that in terms of the exemption for patients, but with impairment, it can still be the case for patients as well. It's not.
That's right.
So how would you measure that?
Well, in Canada, it's erratic driving, so, you know, the highway patrols see you weaving from side to side as they would for other intoxicating medications or alcohol. But, I mean, let me emphasize that THC intoxication is a really hot area of research, and there's people, for example, working with virtual reality goggles to try and develop roadside tests where in 30 seconds you can tell whether someone's impaired. But cannabis impairment is very subtle. That is the problem. Alcohol is very easy in comparison, and same goes with you know, police trying to identify whether someone's intoxicated with cannabis. They're actually very poor at that. There are studies of that, even in trained experts. They don't get it right very often, so there's a subtlety there. Whoever comes up with the roadside functional test will be probably very famous and very wealthy, I imagine.
Yeah, Luamato?
Just follow up, but question perhaps to you, Dr. Wren. In your submission there, you mentioned about Mothers Against Drunk Driving and Health Canada, and they're advised that individuals should wait 4 to 6 hours after using medicinal cannabis before driving. Is that what the law is over in Canada? They have to wait. How does that work over there?
The specifics on the actual law.
Yeah. Is there specific in laws there, or I've noticed that maybe because Health Canada is advising it.
Yeah, I'm not too sure, to be honest. I'd have to take that on notice to actually get the specific wording of it. It'd just be from a clinical advice perspective. That's what we'd be talking to patients about. The duration of a possible impairment, which can actually relate to the formulation and how they're actually consuming these products as well, because that period of impairment can vary between an inhaled product and an oral liquid as well.
Okay, no, thank you, Dr. Wren. No one else likes to add notes anymore?
Well, Danielle, again, wrote the book on duration of impairment, and you'd be familiar with the Canadian system.
Would you like to add to it?
I think, yeah, so we conducted a big review of all of the available evidence around THC-induced impairment, looking at THC's effects on cognitive function and driving performance and all kinds of things like that. And we essentially extracted all the data from the papers that existed and crunched the numbers and ran some modelling and looked at the various different factors that have just been spoken to that might influence the duration of impairment. And so I think most importantly, we found that the dose of THC consumed and the route of administration were important determinants of how long THC-induced impairment persisted, with higher doses causing longer lasting impairment, and inhaled THC oral THC causing longer lasting impairment than inhaled THC. And so what we found overall was that THC-induced impairment typically lasted anywhere between sort of 3 and up to sometimes 10 hours, depending on those two factors. Of course, patients typically probably consume lower doses of THC in order to try and avoid intoxication and things like that. So they might be towards the lower end of that sort of range. But yeah, we do have some good data to inform how long people should be waiting following cannabis use before driving now.
Yeah.
The answer's 5, isn't it?
Well, 5, yeah. It's a bit of a range. We would say 5 would be a good sort of general recommendation.
General sort of hours, 5 hours.
Yes.
Mr. Donnelly,
For that.
Mr. Donnelly, Mr. Roberts have been waiting patiently, so I'll flick
No,
to them.
thank you.
Greg.
Thank you for coming along today, to you all. Professor, I'll direct a question to you, but it might be shared across the panel. Just in your submission on page 8, underneath the table, so the table contains some useful information in other jurisdictions, particularly overseas. But then in the 3 paragraphs below that, just in each one of them, if one reads them, it's got the phrase might also require. So if you take the first paragraph, a nuanced approach might also require patients to not drive during the first few hours. The next paragraph in the second last line might provide an additional layer, and then the last paragraph, last line, might be maintained. So there's some qualifying words there. I'm just wondering, in terms of listing, what might be some qualifiers or conditions around what's being looked at? Is that what you see as the 3 that are the most important, or the exhaustive list of what might need to be considered? Or are they just matters that sort of through your research jump off the page and inform your thinking?
These are the areas where we have a margin of uncertainty, and certainly if you were adopting a safety first approach, which I think we would all agree with, within reason, I guess the ultimate safety first approach is that no one drives ever, but how do you manage the risk? In terms of risk management, I would say that advising not to drive during the first few days would be a reasonable public health message and safety message to give to patients, because, again, going back to tolerance to the impairing effects of THC, would expect any impairment to be biggest when people first use the drug. So that would be something that the AMBER trial could actually if we were to run that clinical trial, could actually show for sure what the trajectory of impairment was over time in patients initiating a THC-based medicine. And also, again, with Danielle's work suggesting that, and not just Danielle's work, other recent work from the University of California, San Diego, has suggested this 3 to 4 hours as being the peak time where you'll see cognitive and driving impairment. So another good safety first message would be, if you take particularly a moderate to high dose of a THC-based medicine, then wait 3 or 4 hours before you drive. That would be a sensible thing to do. And then we do know that THC can exacerbate alcohol-induced impairment, so you might want to give some thought to how to best manage that. Perhaps the combination of high concentration of THC in oral fluid together with a positive breath test would be something that is seen as more hazardous than either of these things alone.
And so just between that first paragraph about the require patients not drive during the first few days of using a THC-based product, and the second one, paragraph, the mandatory time limit, no driving for 3 hours. What's the distinction between those two? Is the first one dealing with if you're commencing it for the first time, the treatment?
Yes, that's right. So the first one is dealing with tolerance, drug tolerance. So, and it's much like alcohol. If you've never had a drink in your life, then a glass of wine will have a much bigger effect than someone who's a daily drinker. And so you're trying to allow people to become accustomed to the unusual feeling that THC can produce and the impairment it can produce when they're initiating THC as a medicine. Whereas the second one, we know that even in people who are tolerant to THC, there can still be some impairment in their driving in the first few hours after use. And so the second one manages that. And even though you may be tolerant to THC, it may be wise if you're taking a moderate to large dose to wait 2 or 3 hours before you drive, just to enhance overall safety.
Just the last couple of questions. In your opening statement, Professor McGregor, you talked about the crash risk goes up, but you said that on the evidence that it appeared to be only marginally, as I understand your opening statement. But then later on, and I think it was yourself, and I sort of stand to be corrected, a reference to between a 10 and 40% increase in the possibility of having a motor accident. Just sort of trying to reconcile those two explanations.
Yes, well, I think maybe the yardstick against alcohol is informative. So if you were to look, say, at a blood alcohol concentration of 0.049, where you're perfectly good to drive under current legislation, unless you're not a commercial driver or a P or L driver, you will be more impaired than if you have had cannabis. So we already tolerate a margin of impairment with alcohol and other drugs. So it's a modest level of increased crash risk, and one that we tolerate with alcohol, and we also tolerate other prescription drugs that have a much greater crash risk. If you have a blood alcohol reading of 0.12, I think your crash risk is something like 20 to 200 times greater. So a 0.4 increase is very small by comparison to both prescription drugs and higher doses of alcohol.
But the 40%, that's quite a high percentage, if that's the figure that's...
Well, if you look at 2,000% with a blood alcohol concentration of 0.08, 40% is quite small in terms of percentage increase. But I take your point, and that is that no one is arguing that crash risk doesn't go up with THC, but compared to other things that we tolerate, that enhanced crash risk is considerably smaller.
Mr. Roberts.
Thank you, Chair. Thank you all for your attendance today. I might direct my questions to you, Professor McGregor. THC affects individuals differently, as does all type of drugs, whether they be illicit or prescription. That's correct, isn't it?
Yes.
Okay, fine. Take that point. Have you ever heard of the hierarchy of risk control before? Are you familiar with that?
No, I'm not actually.
All right. Well, if you're not, we'll leave that. Let's take you then to your statement just recently. In your opening statement, you say the risk level of a crash goes up, and then in answer to my colleague, Mr. Donnelly, you've said anywhere between 10 to 40%. Monash University says 50%. You dispute that, but we're not here to split hairs. There is an increase in risk, though. We agree? Where that sits, we don't know, but there's an increase in risk.
Yes.
Well, in that case, do you think it's appropriate for a parliament to legislate or endorse a change in legislation that would allow for an increased risk of motor vehicle accidents, no matter whether it's 10%, 40% or 50%? Do you think it's appropriate that we should change legislation that increases the risk?
Well, a couple of points, and I might throw this over to my colleagues as well once I've quickly said something. We don't actually know in the case of patients, as I've noted already, whether the risk goes up or not. And other legislatures around the world seem to be able to manage that risk and provide the exemption that is being sought with this amendment. Until we run a trial like the AMBER study, we won't know whether that impairment is real.
Can I rudely interrupt you? And I'm sorry, I apologise, just want to hone on this. So we don't know at the moment, were your exact words?
In the case of patients, we do not know whether crash risk is increased or not.
Thank you. Please continue, and I apologise for my interruption.
Well, I feel like I'm hogging the floor a little bit. Tom, would you like to say anything about this one, and maybe Joel as well?
I think in some sense this comes back to civil liberties, and I think that the real comparison we should be making is to other medicines that patients already do take and drive under the influence of. And I think that's really what we're talking about here. We're talking about patients. We're not talking about people who are using cannabis recreationally. That's a completely different question. And as Professor McGregor's already said, we know that if you've got opioids in your system, antidepressants, even in the first few weeks of treatment particularly, can produce driving impairment. Benzodiazepines, which you may be using for anxiety, something like Valium. We have a lot of other cases already where we know that these drugs do impair driving, but we trust that patients will make responsible decisions around whether they're okay to drive or not. And I think what this is doing is bringing medicinal cannabis into line with those, I suppose, rules or guidelines that we currently already have for other prescription drugs.
So then, and you can either agree to this proposition or disagree. You're suggesting benzodiazepines, opiates, all these other sorts of drugs over here impair your driving, which they do. I agree with you entirely. But what you're saying is, well, perhaps we should just add another one on because these are already happening. Is that basically what you're saying?
I think if we're talking about medicines, then we should treat all medicines equally.
Fine. That's all I have, Chair. Thanks. Chairman.
Thank you. I'll just go to you again, Dr. Wren, because I think in terms of today, you might be the only kind of GP that is before the committee. That prescribes medicinal cannabis. So I just was hoping you could just give us a few examples of patients that you have seen that with conditions where other prescription drugs didn't alleviate their condition, and how medicinal cannabis has worked for them, if you have examples of that, firstly.
I certainly have hundreds, if not thousands, of examples. And I think that this is a really important point where when we're talking about THC-containing medicines, that's slightly different to THC-based medications in terms of the proportion of cannabinoid content as well. As I counsel patients, there are hundreds of products available between high levels of CBD with small amounts of THC, which research has shown that the entourage effect and hypothesis of a whole plant medicine rather than isolates can have a increased therapeutic benefit compared to what we'd refer to as balanced products, so equal parts CBD and THC together compared to high levels of THC as well. And further to that point as well, clinically, pharmacologically, CBD is what's called a negative allosteric modulator. So by combining them together, CBD can actually reduce levels of impairment from THC as well. A couple of really textbook examples of providing medicines that do contain THC. I've seen plenty of middle-aged people between their 30s and 40s that have high levels of anxiety. They've tried conventional SSRIs, selective serotonin reuptake inhibitors, and that can impact their sexual function, which will obviously in turn affect their quality of life. They'll cycle through a couple of SSRIs, potentially an SNRI as well, serotonin noradrenaline reuptake inhibitor, a really, really common antidepressant as a tetracyclic antidepressant, metazapine, can cause a lot of sedation, and especially morning sedation and grogginess on the way to work, causing impairment. So potentially for patients in that scenario, I'd be prescribing something like a 1 to 25 oil, which is usually 25 milligrams per milliliter of CBD, understanding that doses of up to 1,000 and 1,500 milligrams of CBD have been tolerated safely in humans. But it's that 1 milligram per milliliter of THC. It's that presence in the first place that completely makes it illegal for them to then drive to work. So they're forced to essentially sit with their anxiety. Another example would be older people suffering from degenerative joint conditions and osteoarthritis, chronic pain, and to the point that affects their sleep. So for example, a patient like that, a really common scenario is something like a 10-10 oil, which obviously has a substantially higher THC component. So 10 milligrams per milliliter of both THC and CBD. They might be taking anywhere between 5 to 10 milligrams of THC in the evening to assist with their pain, but also to assist with their sleep as well. And current guidelines previously updated at the end of 2021, oral dosing of THC generally can be well tolerated in patients up to around about 40 milligrams of THC per day.
Thank you. And so just with this, if this law passed, so say if we did get changes in New South Wales where people who are prescribed medicinal cannabis were able to drive, just similar to other prescription drugs like, endo and Schedule 8 drugs, as a doctor, you would advise them, say with your patients, I assume it wouldn't be this blanket kind of advice, but how would that change in terms of how you prescribe? Because at the moment you just would say, I assume, you can't drive a THC in your system. This is the rule. How would that change? How would you approach it?
So it'd be discussing the current medications that they're taking as well, and any potential risk of interactions, both in a synergistic manner in psychotropic medications, a combination of a CNS depressant plus THC on top, compared to interactions of hepatic metabolism, which can be possible, especially with antidepressants and certain antipsychotics as well. It's understanding that most people start with dosing of a nighttime, of an evening, to develop tolerance to the effects of the medication. And also potentially to actually start on the weekend where they're not going to be driving, where they, if there are any side effects, they can take note of them without needing to go to their job or anything like that. Another huge part of prescribing medicinal cannabis as well that's not necessarily recognised, pharmacovigilance is greatly improving even in the last couple of years. So between My Health Record and SafeScript New South Wales, there's QScript in Queensland, there's Script Check SA, where we in real time can actually monitor other prescription medication and see is this patient displaying drug-seeking behaviour, and we can regulate their usage through minimum dispensing intervals from pharmacies, from reduced, if any, use of repeats as well, just to actually ascertain what the clinical effects will be before then advising for them to continue the medication.
We do have to wrap up. We are running out of time. We can probably have one final question.
I just wanted to ask, in a way, leading on from my colleague, Mr. Roberts' questions, if we're going to be consistent here, one option is obviously to treat all medicines the same, so medicinal cannabis along with the other prescription medicines. The other option is, of course, to move all of the prescription medicines into the current Section 111(1), so that presence of any licit or illicit drug is illegal. If we were going to do that and be honest about impairment risk, we would have to move to a zero alcohol blood limit as well. So if the state wanted to consistently treat the potential for impairment, we would either have to say we will have a consistent prescription medicine regime, or any presence of any drug, illicit or legal, and any blood alcohol level would be unacceptable. That's, if we're being honest, that's what would have to be put forward, wouldn't it?
That would give you the level playing field.
Yeah.
There's additional aspect to this, just very briefly, that's worth considering, and that is evidence from overseas and to a certain extent in Australia that when people initiate medicinal cannabis for a medical condition, their use of other drugs tends to fall away. So if you're a chronic pain patient...
That's right, you're replacing opiates and benzos
You're actually
with
replacing
cannabis.
opioids and benzodiazepines and sedating antidepressants with medicinal cannabis. And in the hierarchy of risk, although I'm not exactly sure of the theory, but if we're looking at hierarchy of risk, then you're actually improving road safety if you get someone off an opioid, which is more impairing than medicinal cannabis, or get them off Valium, which again is more impairing than cannabis is.
Yeah, that's right. I mean, it's just about, as you say, you either accept some risk, in which case you treat that consistently, or you say the state would have to make the case to the public, we are not going to accept any presence of any alcohol or any substance, legal or illegal, in the system. That's the only way. If we're aiming for a level playing field, that's the only way to achieve that.
Exactly right. And just one very last thing I'd like to say, and that is back in 2015, the Mike Baird, together with Kerry Chant, announced funding for some pioneering clinical trials in medicinal cannabis, and this was a tremendous development which we applauded at the time. This was around about the time that the Lambert Initiative started, and that included the chemotherapy-induced nausea and vomiting trial that I referred to earlier, and I'd like to see this continue into this area. I think the current state government does have a proactive side to this issue, as was illustrated back in 2015, and I think they could do it again by running the world-leading definitive trial on medicinal cannabis and driving. That would be a tremendous achievement.
Thank you so much, Lou. We have run out of time, unfortunately. But thank you so much for your evidence today. And if there is anything further you think the committee should be aware of, please feel free to submit it along with any questions on notice. I think that there was only one question on notice, so the committee has resolved that answers to questions taken on notice be returned within 21 days. The Secretariat will contact you in relation to questions you have taken on notice. So thank you so much for joining today.
Thank you.
All good. So we might just get started with the witnesses we have so far to get them sworn in while we're waiting for Ms Lynch to rejoin. So could I please ask each witness to please state their name and position title and swear either an oath or affirmation. We'll start with Ms Haslam.
My name is Lucy Haslam. I'm the co-founder and director of United in Compassion Limited. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Ford.
My name is Scott Ford. I'm just a private citizen who uses cannabis. And I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms Hester.
My name is Gail Hester. I'm the founding member of the Medical Cannabis Users Association of Australia. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And do we have Ms Lynch yet? Okay, we'll try to get in touch with Ms Lynch again. We'll proceed anyway while we're waiting for Ms Lynch. Could I ask the witnesses, would you like to start by making a short statement? And if statements could be no more than a couple of minutes. Ms Haslam, do you have a short statement you'd like to provide to us?
I don't have anything prepared per se, but I would just like to say that I think medical cannabis patients have been discriminated against in every possible way since it was legalised back in 2016 and before that for many, many decades because of the war on drugs. We're constantly told that there's not enough evidence for cannabis, yet there seems to be not enough evidence that drivers are impaired just by the mere presence of THC. So at the moment, this is just another case of discrimination against patients using medical cannabis for genuine purposes.
Thank you, Ms.
I welcome the inquiry and hope that this is rectified.
Thank you. Mr Ford, do you have an opening statement?
Good morning, and thank you for inviting me to speak at this inquiry. My name is Scott Ford, and I legally use medicinal cannabis to manage chronic pain. I'm a military veteran, and I have had pain issues for around 10 years now. My injuries have significantly limited my capacity to work, and so to keep myself productive, I run a small beef cattle farm. I was a long-term prescribed opioid user. My dosages just kept going up, and the opioid medications became more and more ineffective over time. My pain specialist had advised me on several occasions that I had to get myself off the opioids. In the end, my wife, who was a nurse, pointed out to me I was becoming more and more vague, not really being myself. I had to change my approach to managing my pain, and the solution I found was medicinal cannabis. Now, as a prescribed cannabis user, I've found a medication that is extremely effective for managing my conditions. It's also safer than the previously tried opioid medications. Cannabis dosage has been determined in conjunction with my pain specialist. I experienced no intoxicating or ill effects when taking it as prescribed. The downside is that I can no longer legally drive in New South Wales. It put me in a very difficult position. I live in a rural area, and being able to drive is crucial. If I can't drive, I must be completely dependent on others to go anywhere. At the moment, when I need to drive somewhere, I go early and delay having my morning dose until I return home. By doing this, there is no chance that I am impaired since I've not medicated for more than 12 hours. However, I would still fail an RDT as I would have detectable amounts of THC in my system. I would be guilty of the offence of driving with an illegal substance in my system, even though that substance has been obtained and used legally. As such, I am fully prepared to explain myself to a magistrate if the need arises. I would strongly urge the inquiry to support this bill so that users of prescribed medicinal cannabis can be acknowledged as genuine users of legal medications and not be treated as criminals. I'm more than happy to answer any questions you may have. Thank you.
Thank you. Ms. Hester? You might still be on mute. Ms. Hester, can you hear us?
Yeah, sorry.
Yep, it's okay.
Yeah, Deb was actually going to read our opening statement, so I'm at a bit of a loss here. But vaguely I could probably just read the draft that we did.
We have Ms. Lynch who's just joined. If you
Beautiful.
do you want us?
To her then. Yes, please.
Great, Ms. Lynch, can you hear us? Just checking with the committee staff. Hold on one moment. We're still having difficulties with Ms. Lynch. So, Ms. Hester, if there's anything you wanted to provide as an opening statement, otherwise we might start off with some questions.
I'm just...
Oh, she's come. Yeah.
Yes. Ms. Lynch, can you hear us?
Can you hear me?
Yes, we can. We still need to do. We'll just need you to do either an oath or an affirmation. We've sworn the other witnesses in, and if you could provide your full name and title as well.
I, Deborah Lee Lynch, swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Great, thank you. And did you have an opening statement that you'd like to provide to us? Thank you.
Okay, thank you. Good morning, and thank you for the opportunity to speak today. MCUA is a patient-based incorporated association that has been advocating for cannabis to be legalised for medicinal purposes for all who need it since 2014. But when the law changed in 2016, instead of access to cannabis for medicinal purposes for everyone, we got legal access only for those who can afford it. Approximately 1 million Australians are using cannabis daily, but to date under 200,000 approvals have been processed by the TGA. The exorbitant costs forced far too many low-income earners to self-supply. They are further disadvantaged by the drug driving laws, and they will continue to face a prospective loss of licence simply for wanting a better quality of life. MCUA hopes that some kind of scheme, such as the proposed CAN card, can be put in place to even up the playing field for those who cannot afford the legal pathway to medicinal use if this bill becomes law. We agree that this bill is a much needed initiative, though we worry it will meet the same fate as similar effort in Victoria last year. That Victorian working group commissioned a study which found no justification for medical cannabis driving bans. It also concluded that Australia was out of step with all other countries that have prescription-only medicinal cannabis, which have policies that allow patients to drive when not impaired. Huge amounts of valid scientific research have been done. Sydney University pulled data of no less than 28 publications. This is consistent with many other local and international studies and opinions held over the last decade or more. No accurate devices available to measure impairment or safety risk. A 2019 study found that the Australian public are being tested with what amounts to faulty equipment. As well as false positives and negatives, the accuracy and sensitivity of the two devices fell below the levels recommended by the European Union authorities. Yet no moves have been made to introduce a more accurate testing system, or any kind of impairment or sobriety test has been employed. When science-based evidence and professional opinion is so conclusive, the public begins to question why the lawmakers are not listening. Statistics show that the current laws have had little to no impact on decreasing the road toll, and these expensive tests are increased year after year despite their failures. One has to question the validity and benefit of the regime and its impact on society. Cannabis is a legitimate medical treatment and must be treated like any other prescribed medicine, where the patient is the judge of whether or not they are impacted and are safe to drive.
When I was saliva tested in New South Wales last year, I was extremely fortunate in that I was represented by a solicitor pro bono and already had a TGA approval documents and doctor's reports to submit to the court. I'd obtained these expensive documents with the help of donations from our community to assist with an ongoing court case in Queensland. The high cost to obtain evidence for defence and to seek legal assistance is another issue of grave concern to us. TGO approval via the doctor cost me another $450. My case in the New South Wales courts resulted in no conviction, no penalty and no loss of licence. Like too many others, I can't afford to get the $1,920 per month prescription filled and am forced to depend on self-supply. Patients taking a recognised treatment should not have to go through the expense or level of stress to enable them to keep the right to drive that any other patient taking prescribed medication enjoys. From MCOA involvement with the cannabis community, we see that some patient drivers are being treated with discretion. In some courts, patients like myself are not being penalised. Some magistrates appear to see the need for this kind of change to the law. It is our hope that this inquiry will bring about change that will ensure all patients get a fair deal when it comes to drug driving. Thank you.
Thank you so much. The committee staff have told me that the vision might not be great in terms of seeing each of the committee members. So when I hand over to each committee member for questioning, maybe if you'd like to just state your name. And if you can't see me, I'm Chris Rath. I'm the chair of the committee today. So I'll flick it over to questioning. Ms. Fairman.
Thank you. Kate Fairman here. Thank you all for appearing today and also for having the courage to speak out and to advocate in your various ways that you have for some of you, over many years. So thank you again. I wanted to start with you, Mr. Ford. Again, thank you for making a submission and being willing to appear today, and it is a courageous thing to do sometimes. I have spoken with a number of veterans, actually, who have had quite astounding benefits from taking either medicinal cannabis, whether that's just CBD or CBD THC in whatever forms, after having tried for many, many years different drugs to deal with what was particularly post-traumatic stress disorder. And I understand that there are even support groups for veterans that around the benefits of medicinal cannabis. Would you like to just talk to us a bit more about the reasons why, if you're happy to, why you're on medicinal cannabis and how it has helped you, and whether other drugs didn't, and whether you also know of people similar in the similar situation as you are?
Well, for myself, and I'll speak for myself, I had used a whole gamut of different pain medications to try to manage my arthritis pain and back pain and everything. Over a long period of time, the conventional medications just lose their efficiency on the body. And I found that once I switched over to the medicinal cannabis, and I'm using an oil that's a 50-50 mix, I've got off all opiates. I just use some Panadol Osteo each day. That's all I've needed to use. I've actually dropped off my antidepressants because my overall mood and health has improved a lot. And I do know of many other veterans who use medicinal cannabis. This seems to be a very, very therapeutic medication. And as far as I've seen, there's been no downsides to its use. That sort of cover what you're
Yeah, thank you. That's great. And so in terms of driving, so you have said that you have to think about when you drive and not take the medication, that's for pain relief. So in the morning, for example, you were saying you try and get things out of the way in the morning. Was that right?
Yes. The only reason I'll skip my medication of a morning is only if I've got to go and drive my car. So, and that's only to reduce the detectable limit in my saliva. If I'm going to go out and use the chainsaw, I'm going to use the bobcat, got to go and use the tractor / work on hills, it's not a problem because no one's going to drug check me in the on my own property. I've noticed when I started trialling medicinal cannabis, I found it was quite obvious when you can feel a level of impairment come on. It's just things sort of start to slow down. For myself, things slowed down. I could feel it. Well, hang on, I'm not quite right here. And it was quite easy to say, oh, okay, I won't do anything that I shouldn't do. It's like just being a responsible adult. But when it comes to driving the car, I don't want that in my system. I don't want that THC in my saliva because I'm guilty of an offence. I don't see it as an offence.
Thank you. And thank you. I wonder whether either Ms Hester or Ms Lynch as well, just in terms of representing medicinal cannabis users, whether there are stories as well of the replacement, if you like, of medicine, and Ms Haslam, you would have it as well, but the fact that medicinal cannabis is replacing potentially sometimes a cocktail of drugs that can have severe impact on people's quality of life, plus their ability to function. Ms Haslam, I might go to you first, actually, whether you care to comment on that.
Yes, look, I can say that that's something that I come across all the time. We recently held an Australian Medicinal Cannabis Symposium only about 4 weeks ago, and there were many, many people there who relayed that story of being able to basically use cannabis as an exit drug to opiates and benzodiazepines and many other very harmful drugs. Just Sunday, I received an email. If I can read it out, it's a good example of the kind of emails that I get quite regularly. Hi Lucy, my name is TT. I'm from Inverell, New South Wales. I've been trying for years to find something or somewhere that can help me. As I came across some articles about your cause or fight for medical marijuana in New South Wales, I'm wondering if there's any way I could get some help from you. I'm 24 years old and a father of 2 with a new baby on the way. I use cannabis as a pain relief for my chronic degenerative spine and for my depression and anxiety. I've recently found myself in trouble with the police and have to go to court for having prohibited drug in the system while using medical cannabis behind the wheel of a motor vehicle. I've previously been prescribed other drugs for my problems, but they either don't work or they turn you into someone you're not. It makes you feel like a zombie. I don't get anything done through the day. I can't play with my kids or anything, and I don't want that to be my life. Please, can you help me in any way? That type of email is very common, very regular. I meet many veterans like Scott who use cannabis really to exit all the very dangerous and addictive drugs that they've been put on over many years, which haven't actually met their needs, but then they find this incredible relief from cannabis. So it's something I feel very strongly about, and I think that, you know, this is just so necessary. We really should be basing what we're doing on scientific evidence and on and really on equality, and there's no sign of equality in this debate.
Thank you. And whether Ms Hester, do you want to comment on that as well?
I think Deb wants to take that one.
Sorry, Deb, yep.
Ms Lynch, I think you're on mute.
Sorry.
Oh, there she is, right.
Yeah, I agree with everything Lucy said. We have so many people who say exactly the same thing. We also have had people who have been roadside tested. There's one man in particular I'm thinking of. He had his 6-year-old daughter with him. They were off to go fishing. He was on the way there, and they were actually taken back to the police station, and both of them were put in a holding cell. And, you know, these are the sorts of instances that are going on in the community as well.
Thank you, Ms.
Yeah, I
Jackson.
think just to follow on from that, I mean, Ms. Haslan, you said in your submission that the issue of driving laws is one of the major barriers. And I just ask you to elaborate on that, because I think some people might see all of the issues in relation to access to medicinal cannabis and think, God, this driving thing isn't such a big deal. It might seem a little bit obscure to people at first blush how important the issue is. So maybe if you might just elaborate a little bit on why the issue of driving laws is actually such a major barrier.
Well, I think for any Australian, we just assume that we have the right to drive. And when you put that in the context of using medication, we have the right to use medication that meets our needs. But those two things don't meet in the middle in Australia, sadly. And it's not based on scientific reasons. It's just based on really unjust laws. So, back in 2020, we fought for and won the right to a federal Senate inquiry into the barriers to patient access. And for every cannabis patient, bar children pretty well, driving is an issue that they have to consider. People are even afraid to drive with CBD only in their system because there's such a lack of education and awareness about it. So it's impacting many people. As Scott said, particularly rural and remote communities where there's a lack of public transport, this is your access to healthcare that you're not allowed to maintain. And so it's very much impacting probably more than people realise unless they're in that situation. But emails such as that I got from that young man, they're just so commonplace. So I think if the truth were known, there wouldn't probably be there would be every hand up of patients using medical cannabis that this is a concern for them. And some of the outcomes are very dire when you are charged. It can be the loss of your right to work. Because we all need our vehicles to access our employment. So it's a very big issue.
Thank you, Ms. Haslam. And Mr. Ford, you talked about your experiences both on prescription medication such as sort of opiates and benzos and prescription cannabis. Are you aware of individuals who are resisting moving off their prescription opioids and benzos because it is legal to drive with them in their system? Is that something that is keeping people on medication that they don't really want to be on for all of the issues that you've raised, because under the present regime, the presence of those drugs in their system isn't a disqualification from driving?
100%. I know a lot of people who haven't switched to medicinal cannabis. They've tried it and they've found it effective, but if they're still working, you have to have your car. And then, like up here in the Northern Rivers, we get slammed with like RDTs. They'll just come up here and they'll just swamp the area. So all of a sudden you can't go to work. You get picked up, you don't have a driver's licence. So therefore, people don't want that problem. They want to be able to maintain their driving ability without worrying about being criminalised. And the people that I know of who have been trying the cannabis have found it effective for themselves, but the same as I have. And it was a big decision for me to go, well, all right, I'm going to drive, I don't care. Take me in front of a magistrate. I was going downhill on the Alexia that I was using and also OxyContin. And as my wife had said, I was getting really vague, and I realised what I was doing wasn't safe using those other medications. Now I've gone on the cannabis. I know what I'm doing is safe and I can tell when I'm okay. And then other people that I speak to use it, that have used it, do use it, have the same things. It's just they're too scared to go and get prescribed, and you can't drive with it because as soon as you get pulled up, you're done. You've got to go and face a magistrate, and it's just not practical. The law is, it's remnants from the war on drugs, that you're charged with having an illegal substance in your system, it is prescribed legally to you. It's just time this was changed.
I'll just have one question and then throw over to other colleagues. I wanted to ask a little bit from Ms Lynch and Ms Hester about the CAN card that was mentioned in your submission. And Ms Lynch, you talked about, you know, your experiences with judicial discretion in relation to your charge. And this is, I suppose, just another example at the police level, providing police with information about people's health conditions and the reason that they're using cannabis medicinally, therapeutically, the card providing an opportunity for police to exercise discretion and the success in a way of that regime in the UK. I wondered if you could just talk a little bit more about how that has successfully worked and how you think such a regime might be able to be rolled out in Australia.
Okay, the CAN card, Gail actually initially stumbled on that and we got into contact with the ladies in the UK who have set that up. Basically, it's run by a not-for-profit association. There's, I believe, a £30 fee associated with the card. Now, £20 of that goes to a proper ID checking platform in the United States, so that each person who applies for one of these cards is the person, you know, who is prescribed. In the UK, they have to state what conditions they have. Our privacy laws wouldn't allow that, but there are ways around that, in that we could get recommendations from doctors or letters to say that, you know, this patient does qualify for a medical cannabis prescription in order to fulfil that part. Now, the second part of the card is that these lasses liaised with the police over there. They haven't had a change in legislation, but it's been a change in standard operating procedures, where I believe 98% of all people who are stopped by the police now, if they have this card, the police are walking away and just leaving them. For those 2% who aren't, who are still prosecuted, there'll be a 24-hour call centre attached to the card with access to immediate legal advice. So that's basically, you know, like an amnesty card for those who can qualify for medicinal cannabis, but like myself, can't afford. My prescription is more than my fortnightly pension. I can't afford to go the legal route, and I am like so many other thousands and thousands of people in that same situation.
Other questions from committee members?
I'm happy to keep going.
Rose asked a couple of very good questions that I was going to ask.
Just to follow up on that then, Ms Lynch, and then I might throw back to Ms Fairman. She probably has another question as well. Presumably there is this particular issue of people who are on low incomes, who can't afford a legal medicinal cannabis prescription, who are most likely to be very negatively impacted by losing their licence.
Oh, exactly. I mean, you know, these people, for the most part, are not well, so they need to attend medical appointments. They need to, you know, so many different things. I mean, personally, I have physio twice a week. If I lost my licence, I would have to rely on someone else getting me to all of those appointments. And so there are so many people who are unwell, who use cannabis, who are in the lower income group. When you think that there's a million people using cannabis daily and only 200,000 TGA approvals, that shows you that I'm lost for words, you know, the ratio of how many people are using illicitly.
Do you want to ask?
Yeah, I can. Yeah, Ms Haslam, I might just throw to you again. And interesting that you're at the Medicinal Cannabis Symposium just 1 month ago, because you may have some more stories for us. But you're also from regional New South Wales, and I wondered if you could just explain to the committee how this particularly impacts on people from regional and rural New South Wales because of, you know, lack of transport options and other things. Would you care to comment on that?
Look, I think a few years ago I did quite a bit of work with the New South Wales War Widows Guild and the Country Women's Association, and they were very supportive of, you know, trying to make some changes in this regard, because they appreciate that for anybody that lives rurally, you know, a licence is a lifeblood. You know, I've heard of parents that need to drive their children to a remote place to catch the school bus. So if you think about that, you know, if that person lost that capacity, what happens to that child's access to school? You know, having a driver's licence is just essential to everything in the country. It's essential to how you get your groceries or how you get supplies for your property. It's just you know, you just can't do without it. And I do agree with the girls and with Scott that a lot of people have to make that real decision. Do I risk it, or, you know, or do I forego the treatment that is best suited to me? So that's a terrible choice that I don't think any Australian should have to make. If they're not impaired and they feel fit to drive, they should be able to drive in the same way that a patient being prescribed morphine is able to make that decision and drive.
And it is. Thank you. It is that, and I think the previous witness, Dr. Joel Wren, made this point as well. Like, people who are taking, I mean, millions of Australians are taking drugs legally, and some illegally, but taking drugs to deal, just to stick to the legally, taking drugs to deal with all of their conditions on the advice of their doctor. And there's, you know, you're old enough to drive, you're old enough to get a driver's licence, and then there's also the just the responsibility that individuals then take to keep themselves safe behind the wheel and to kind of abide by what the doctor's telling them. So I suppose I'm trying to get to a point that ultimately that's what people are doing every single day with the drugs that they are already being prescribed, whether or not it's cannabis, aren't they? Ms. Haslam?
Absolutely, 100%. You know, and I mean, you can argue that patients that are well controlled and have their pain managed or their tremors managed or their spasm managed, they actually are a better driver if they're medicated adequately on cannabis. So, you know, we have to really determine whether the rules and regulations as they stand, are they about raising revenue or are they about keeping the roads safe? And if it's a safety issue, then I think you need to look to, you know, studies that are done around the world which have determined that actually there's not a negative impact on road crashes. It's not a safety issue. So I just think it's really a very outdated system that's really, as Scott mentioned, it's linked to the war on drugs. It's linked to
Do you have another one?
determination not to change. And really what it has to be about, it has to come back to the fact that it's discriminating against legal patients who are, you know, have the right to choose the medication of their choice.
Mr. Donnelly, do you have a question?
Thank you, and thank you all for joining us today. You might not be able to see me, but I'm just sitting around on the edge of the table. Just perhaps starting with Mr. Ford. The question about impairment and the comments you made about your sense of knowing when you're impaired and when you're not in terms of the medical cannabis. Could you expand on that so we understand a bit more clearly what you mean by that, about knowing whether you're impaired or not?
Yeah. When I first started trialling the medicinal cannabis, and we sort of had to work out a dosage that was going to work for me, and we started low and we sort of gradually built up. What I found was once I started to feel an effect of the cannabis, I had sort of an uplifting effect in my body first. That was the first thing that I sort of felt. And after that, I think, well, hang on, maybe everything's not as it should be. Everything's sort of just not unpleasant, but you can tell that there's a little bit going on that you're not fully. You can tell in yourself that feeling after that comes on. So that first one, I get that bit uplift and everything, yep, okay. Then I start to feel a little bit like, oh, hang on, maybe I'm not quite right. So then I go, well, hang on, all right, that was the time to, that was the dosage for me that I didn't want to go beyond. So with taking the oils and getting up to my 2 mils that I take, that's been really effective, and I don't have any of that effect where I notice that things aren't quite right. I did at times have a higher dosage, trying to find out where we were, but then it's really obvious. And if I compare that to drinking alcohol, you can have 1 beer, you'll have 2 beers, you'll think, oh, I'm all right, get on to your 3rd beer. You might still think and feel like you're okay, but the action in the brain with alcohol and the cannabis is very different. And I suppose the best way to put it, you will detect in yourself change. It's not bad, it's just you'll go change. And at that point, I think, well, that is when my impairment is beginning beyond that point. I don't get to that point with my general dosage of my cannabis.
Can I just expanding on a bit further, if I could? So you indicated there that when you commenced the regime of the medical cannabis, there was a starting off at a lower dose as you and your clinician were working towards a sense of what was the right level. Has that been stable? Or, in other words, that sense of being impaired was at the start, but now are you saying that now that's stable, or it still fluctuates?
It's still stable for me. My medication I started with 6 mils daily of the oil. I've now actually reduced the oil down to just 4 mils. And I have that 2 mils of the morning, 2 mils at night. And I find it's just been stable. And it's been like that for probably close to a year now. I've been on that dosage with no changes. I haven't had that impairment feeling come on. It's worked really well.
So for you, the issue was at the commencement of establishing...
So the issues that I found when I felt the highs as such, and the maybe a bit of incoordination, was just with trying to find that right dosage for me in the start. And you do that with your doctor, and you just discuss how it's affecting you. And really, if you want to function properly, you don't want to be high, because it's going to affect how you live your life. Is it active or not? If you get high, you end up a bit more of a lounge lizard. When I don't want to do that. I prefer to be an active individual.
Can I get Ms Haslam's view on that as well, because she speaks for a lot of other users, because that was Mr Ford's opinion, but just to see what Ms Haslam as well, is that the case with other patients?
Well, just on the matter of impairment
that's right. No, that's what it is. Yeah, sorry.
Yeah, please proceed, Ms Haslam, yeah.
I was just going to say, I think Scott is spot on. You know, I've been around this situation enough now and around international and Australian experts that the old adage of start low and go slow is very much how cannabis is prescribed by doctors, and it's very much about patients titrating their dose till they get to the point where they find that sweet spot where they get maximum relief, but they're not impaired. And, you know, I think there are very few medical cannabis patients who would take more than is required to get a therapeutic dose. You know, largely when you think about the cost factor, patients are struggling as well to afford it as it is. So they're only going to take what's absolutely necessary. So, you know, impairment in that early stage when you're trying to find a dose, that's quite usual with any medication, and I don't think that medical cannabis would be any different in that regard, but it's certainly not the overall goal is to get high. It's very different with medical patients. The overall goal is to find that therapeutic sweet spot where their condition is managed and there is no high or impairment.
And just on the definition of...
Might be the last one, Greg, if that's okay.
No, that's fine.
Yeah.
That. No, that's fine. Yeah, no, that's fine.
You're good. So we have run out of time, unfortunately, but if there's anything further you think that the committee should be aware of, please feel free to submit that, as well as committee members might have additional questions that will be sent through to you. I don't think there were any questions on notice in that round. Yeah, thank you so much for joining us today, and we'll be in touch regarding next steps. Thanks so much.
Thank you very much.
Thank you.
Okay, we'll get started. Do we have Dr. White online? Not yet?
No, not yet.
We'll start with you, Mr. Timms. If you could state your full name and position, and then either do an oath or an affirmation, please.
Thank you, Mr. Chair. My name is Michael Timms. I'm the current Deputy Chair of the New South Wales Chapter, Australasian College of Road Safety.
Great. Thank you. And while we wait for Dr. White, do you have an opening statement you'd like to provide?
I'll just quickly take the oath, Mr. Chair.
Oh, yeah, sorry.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God. In regards to the opening statement, the Australasian College of Road Safety is the region's peak membership association for road safety, with a vision of eliminating death and serious injuries on the road. ACRS has state chapters that organise local events and consider jurisdictional matters. Parliament is aware of the contributions made by the New South Wales chapter to recent inquiries. The issues being considered today are not unique to New South Wales. At present, ACRS is yet to develop a national position regarding medicinal cannabis. The ACRS New South Wales submission confines itself to the inquiry's terms of reference, the wording contained in the draft bill. Should the bill ultimately become law, we seek that it be clarified so the exemption applies only to the holders of a current Australian driver's licence. Only the holders of an Australian driver licence are required to attain medical fitness to drive clearance.
Thank you. And while we wait to connect with Dr. White, we might start with some questions. Who'd like to start? Yep, Mr. Donnelly.
Yes, thank you, Mr. Timms, for coming in today. And if you wish to take this on notice, you're welcome to do so. But in that opening statement, you referred to the fact that the Australasian College of Road Safety have not at this stage formulated a position. Is that a matter, just in regard to the matter we're dealing with in this inquiry, is that a matter that's being examined at the moment or being considered at the moment?
Well, I think it was Professor McGregor this morning said that this issue is not going away. So certainly it is something that nationally we need to consider. We are a national organisation. It's not appropriate for us as a state chapter to form separate positions. We have an extensive database of previous conference and journal submissions available on our website. Both of those, they happen to be peer and non-reviewed. In my preparation for my appearance, I searched that database for previous work on this topic of medicinal cannabis, and that search thus far has yielded no results. So obviously we would have liked to have had something to come back to and assist the committee with. But I note that previous witnesses today and discussion around some current and possible emerging research projects, and I would, on behalf of the college, invite those researchers in due course to submit papers to future Australasian College of Road Safety events, as we do believe that the submission and peer review process would assist both the college and other authorities.
No, thank you. Can I just take you to your submission, and specifically just on the bottom or towards the bottom of the first page, where so this is on page 1. The second last paragraph before the final paragraph, which is a quote from a publication, that ACRS notes that assessing fitness to drive, a joint Ausroads or Austroads National Transport Commission document, is that a document which is created with yourselves? No, I understand the co-authors of that document.
Yeah. Austroads is basically the association of all state and territory transport associations. Right. And the NTC, the National Transport Commission, has oversight of the development of a range of new and emerging policies and technologies. For example, NTC are heavily involved in connected and autonomous vehicles. That's the sort of space that they operate in. And that publication is a guide for physicians as to how they should manage patients as they come to them. And there's obviously the holders of a driver licence, and for those of us many of us ourselves may need to have that clearance, or others also, like myself, are managing parents that have to go through that process, and that's the policies that they need to assess fitness to drive in a consistent framework nationally.
One final question, if I may, Chair. Part of this inquiry, in terms of considering the issue before us, is a discussion around the matter of impairment, driving impairment, or what might be an impairment that impacts on a person's ability to drive. I take your comment that the organisation hasn't formulated a position at the moment on this, and I'm not pressing you further on that. But generally speaking, the matter of driver impairment, are you able to sort of just make some reflections about what it is? Is it something that's able to be measured and quantified? Is it more elusive? Are you able to just talk a little bit about driver impairment?
Well, it certainly depends on what we're talking about. If you look at the issue of driver fatigue and tiredness, that's can be quite subjective. Alcohol is measured through scientific instruments, and governments throughout the world have adopted what they call per se requirements. So in New South Wales, obviously, for the bulk of the motorists is 0.05. Now, a driver in excess of 0.05, we're not necessarily saying that driver is impaired, but they're just saying that on the bulk of the evidence at hand, researchers, academics and governments have concluded that 0.05 is about the maximum trade-off between safety and mobility that they're prepared to allow. When you look at drugs, other drugs, be they illicit drugs or prescription medication, things again start to become a little bit more grey, as I think the researchers this morning testified to.
We're just trying to get a hold of Dr. White, so just bear with us one moment. Doing it the old
I hope he's not on South Australia time.
White.
It is.
Hi, it's Marion Thompson from the Committee Secretariat. I've just got the committee ready to swear you in, to give evidence, if you're okay.
Yes, I am.
Dr. White, it's Chris Rath here, the Chair. If you could please state your name and position title and swear either an oath or an affirmation.
Okay, my name is Michael White, and I will do the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Did you have any opening statement you wish to provide to the hearing?
Yes, I do. A couple of things about myself. I'm a 70-year-old person and have been retired for about 7 years. I've worked as a secondary school teacher, university teacher in psychology, and a public servant. I was employed by the South Australian Public Service for about 25 years, where my main roles were to manage road safety and workplace health and safety research grant programs. I've been interested in drugs and driving for a long time. About 25 years ago, I was the South Australian Government representative on the National Austroads Drugs and Driving Working Group. I've co-authored 5 peer-reviewed journal articles on drugs and driving, and since retiring, I have maintained an interest in research on the road safety consequences of using cannabis. I now regularly distribute news briefings on cannabis use and driving to about 600 researchers and policy advisors around the world. Would you like me to briefly describe my 2 submissions?
Yes, please. Yeah.
Okay. Submission number 49A summarises the findings of 2 literature reviews that I have co-authored. The epidemiological review found that the prior use of cannabis increases the risk of crashing by about 40%. However, if study biases are taken into account, it seems that cannabis has no overall effect on the risk of crashing. My second review was an impairment review, and it concluded that impairments from the use of cannabis are difficult to detect. They are often not found, especially for regular users of cannabis, and when they are found, they are relatively weak. The review observed that impairments that are statistically significant, found in the laboratory, can nevertheless be trivial in the context of road safety. I will now briefly describe submission number 49, my other submission. In 2013, a researcher from the Monash University Accident Research Centre, MUARC, conducted an evaluation of Victoria's roadside drug testing program and concluded that the program had been very successful. In submission number 49, I provide a critique of that evaluation, where I argue that the evaluation is invalid. Since then, the MUARC researchers have conducted a second enthusiastic evaluation of roadside drug testing in Victoria, and I believe that the second evaluation is also deeply flawed. So I guess what I'm saying is I don't think there's any evidence that roadside drug testing works in Australia. And that's it from me. Yeah.
Thank you. We'll continue with the questions, and if it's difficult for you to hear us, let us know, and I'll repeat the question. And I'll just ask committee members to speak as clearly and loudly as possible. So I'll hand over to other members of the committee. Ms. Fairman.
Thank you, Chair. Kate Fairman here. I might direct my first question to Dr. White down the telephone. Dr. White, could you try and explain to the committee as simply as you can why you have said that the research both times, or the evaluation both times by the Monash University Accident Research Centre into the success of roadside drug testing is deeply flawed, in your words?
Yes. The first evaluation, I think, was conducted by Cameron in 2013. Now, as part of their second evaluation, the MUARC researchers themselves now say that one's invalid. Perhaps not in exactly those words, but they've now discarded it. And they've said it was based on, I used the word cherry-picked data. They used a similar, in a webinar, they used a similar term, which I can't quite remember, but it was something like adventitiously selected data or something. So they've acknowledged that the data they based it on was unrepresentative, and they're no longer actually supporting their own first evaluation. So it sort of comes down to the second evaluation, where I make a number of points about it in my review of it. The first one being that it's unreplicated. A good practice in epidemiology is to develop a model and then just see if it can be replicated against other data. And if it can't be replicated, it might have just been idiosyncratic. It might have just been a description of the data you happen to have with its quirks in it. So they've applied it without replicating it to validate it. And now, if they'd tried to replicate their first model, they'd have failed, and they acknowledge that now, that it was not replicatable. It was a dud model. You'd think that having acknowledged that their first model was not replicatable, they'd try to replicate their second model. But they haven't. They've developed it on one set of data which may be idiosyncratic, and they've applied it and said it's remarkably successful. The roadside drug testing is remarkably successful. My second point against it is that it flies in the face of reality. Their evaluation claims that that increases in roadside drug testing reduce the prevalence of drugs in road crashes. But if you look at the 15 years or so of data that is available to them, exactly the opposite happens. Over those 15 years, as roadside drug testing has increased, so have the prevalences of THC and methamphetamine in road crash victims, injured people. So it fails the pub test. I have three other objections. Would you like me to go through those? Or?
Need to do it very, very quickly. This is important though, because it's one of the main research. So
Okay. Yes, I'm having a little trouble hearing Kate, but I took that to be a yes.
Yes. Very, very briefly, if you could recount the three.
Yes.
Yeah.
The next one is that it uses the variable it uses to predict methamphetamine crashes is a very odd variable. One thing it says is that the only thing that matters is the hit rate. How many people you find through roadside drug testing that have actually got the drug in them. Now, you can increase the hit rate by simply doing away with the general deterrents booze bus come drug buses and just have car-based, intelligence-based, and even if you greatly reduced the number of tests you did, but just made sure you targeted people who you knew were drug users, you get a remarkable hit rate, and they say that you could do away with almost all of your enforcement and still have a remarkable success. And so they've sort of thrown out general deterrence. And I think there's logical problems with that. I'm not convinced that the data they've based their model on is good data. It's what's called time series data, and with time series data, a whole lot of things co-vary, and it's very difficult to know what causes what, because over time, as one thing changes, another thing changes for reasons that are not often evident. And my fifth point is that it makes unsupportable and self-serving assumptions in its application to crash reduction. Now, it makes a number of such assumptions. It's hard to tell because they hide their assumptions. They're not easy to find. But one of them is the assumption that prevalence equals causation. That if 100 people, if the drug is found in 100 people, the prevalence is 100 people have got it in them, say cannabis, then that, in 100 crash people, then the cannabis caused the crash in all 100 people. And that's just nonsense. To begin with, if a lot of people have cannabis in them, but they're the innocent victims of crashes. You know, if they were T-boned at an intersection by a drunk driver going through a red light, but they had cannabis in them, this analysis assumes that they were responsible for their injury. And New Act researchers know this. That they're being sneaky here. They know full well that most cannabis-positive injuries are not actually caused by the cannabis. they're caused by other factors. And there are a couple of other assumptions which it's a bit hard to know if they make or not, but I think they make the assumption also that if alcohol and cannabis are involved in a crash, then the cannabis caused the crash. Now, in most cases where alcohol and cannabis are both involved in, a person has used both alcohol and cannabis, in most of those cases it'll be the alcohol that causes the crash. So they've made some assumptions that exaggerate the apparent benefits from the program.
Thank you, Dr.
That took a couple of times, so I'm happy.
Ms. Jackson.
I just have a couple of questions, Mr. Timms. Just briefly, you mentioned earlier that, for example, when you were doing a review of the studies that you had on your database, there wasn't anything there that was able to assist you. So presumably, you would be a supporter of the government ensuring that there was more research done about the relationship between dangerous driving and those taking medicinal cannabis. That's something that you would be a supporter of?
It's very interesting.
Sorry, Chris, could you just repeat that?
Sorry, that was to Mr.
question
Timms.
was to Mr. Timms, who's here in the room with us.
Oh, sorry. Okay, yeah, right.
Yeah, thank you. I lost my train of thought. It was. We had a look for that, as I said, the research, and we're very much a research-driven organisation. We have our annual conference every year, and at that conference we have dozens of people come along and present PhD papers where they test certain hypotheses. So, I mean, certainly a project of this type of nature would be welcome. And I suppose even just going back a step, it appears to me that it's obviously a legitimate concern of people who have patients who are prescribed medicinal cannabis, and I caught the end of the previous session, but it's obviously they hold a concern, an apprehension that should they be subjected to a roadside drug test, they would prove positive. I don't even think there's been work to actually prove under what circumstances that occurs. So, we're really in search of knowledge in this whole space.
Yeah, I mean, there was evidence from researchers on the first panel of witnesses that we heard that, they had similarly struggled to gather a lot of useful research and had put forward proposals in relation to the government partnering with them to undertake further research. And I'm just sort of clarifying that, that is something that you think would be a useful contribution.
Oh, certainly. And again, to reiterate my opening statement, the College of Road Safety would welcome that type of research, and we'd like the opportunity to review it.
Excellent. Just my next question then. You referred to in your submission and in response to my colleagues' questions, the sort of, I just want to get the terminology right, the assessing fitness to drive work that, who has done it here? I'm just looking up your submission, Ostrodes and the NTC. Looking at that document, that is a very long document. It's a sort of almost 200-page document that provides guidance to medical practitioners who are working with patients in assessing their fitness to drive. And I suppose, I appreciate you do not have a specific position in relation to medicinal cannabis, but one of the concerns people would have if we did remove an automatic zero tolerance disqualification to the presence of THC is that people who were prescribed cannabis by their doctors would potentially be driving when they shouldn't be doing that. I guess just your reflections generally on how much work has gone into providing guidance for doctors in general who are prescribing medications to patients. It's not a flippant thing, is it? It's a very detailed, comprehensive engagement with doctors who are prescribing all kinds of medication to people who hold driver's licence.
It's a very serious topic, and obviously these fitness to drive standards apply across the country, and I think in the submissions that I've read, that relationship between patient and doctor is critical in this whole process, and ensuring that doctors have full visibility of the range of medications that patients are on. the Boxing Day crash in 2017 comes to mind, where it wasn't a factor. Medicinal cannabis was not a factor in that particular crash, I'll be perfectly clear. But the coroner in the summation said that no single doctor had a clear view of what the driver who was attributed to being at fault as to that particular person's history of presentations at hospital or what that person was being prescribed. So it is very important that we get this, get the doctor-patient relationship right.
Methadone, wasn't it, if I'm right? Was it methadone?
And a range of other drugs.
Absolutely. Ms. Behrman, did you have another question for Mr. Timms, or did you want me to keep going?
Yes, if you have one, well, I can...
Oh, Mr. Roberts, sorry, I want to make sure that others have...
Sorry.
Yeah, Mr. Roberts.
That's okay. Sorry.
I don't know if you can hear me. Can you hear me all right, Dr. White?
Just yes.
Right, we'll try again. I'm closer to a microphone now. Can you tell me, does the presence of THC in somebody increase the chances of them being involved in a motor vehicle accident if they're the driver of the vehicle? Is there an increased risk factor?
The I guess acceptable answer from the road, from the epidemiological research, and this seems to be the answer that is mentioned in a number of the submissions, including I think the government submission, is that the evidence, most of the evidence points to about a 40% increase in the risk of crashing. Now, in my literature review of the crash information, I come up with, in White and Burns' literature review, we come up with much the same conclusion. So we agree so far that THC positive drivers seem to have a 40% increase in the risk of crashing. However, in my literature review, so that would be the conventional answer. In my literature review, I go one step further and say perhaps some of the studies suffer from biases of various sorts. And we identified a range of possible biases and scored the studies for biases, and we concluded that when you take the biases into account, it's possible that cannabis makes no increase to the risk of crashing.
Well, thank you, Doctor. I'll just really interrupt you there because we are on the clock and I want my other colleagues to have their chance. Did you listen to any of the evidence earlier this morning, particularly that evidence presented by Professor McGregor from the University of Sydney?
No, I haven't been listening to it, but I've read Ian McGregor's submission, and it looks to be an excellent submission to me.
Yes, certainly. But Mr. McGregor, in evidence here this morning, albeit he's probably a proponent of this bill, if I could suggest that, says that there is an increased risk of motor vehicle crashes anywhere from 10 to 40%. Not that it has no effect at all, as you're suggesting.
Yeah, yes, and I acknowledge that that is the commonly accepted view, 40%, and from the literature. That is the view from about 3 perhaps recent literature reviews, including my own, unless you go the one step further and try and work out if some of those studies were affected by study biases. So I agree with Ian McGregor that the normally accepted view would be 40%.
Right, fine. That's all I have, Doctor. Thank you very much.
Just a follow-up on that. It's Rose Jackson here, Dr. White. Oh, hello. Sorry, we're moving a little. we're just moving the little speaker. Can you hear me, Can you hear me, Dr. White?
I can, yes, thank you.
It's Rose Jackson here. I just wanted to follow up. In that literature review, are you able to provide any clarity about whether any of the research relates specifically to the risk of crash for medicinal cannabis patients who are sort of regular users of a prescribed medication in consultation with their doctor? So I guess what I'm saying is, we know that there is a difference between someone who is a regular user of medicinal cannabis taking that substance in consultation with a doctor and, say, you know, a young bloke who's stoned off his brain. Like, those two individuals are different, but they both have potentially THC in their system. Does any of the research go into those differences and specifically look at medicinal cannabis patients taking a substance legally in consultation with their doctor?
Not that I'm aware of. Our crash study, our epidemiological review study, doesn't look at that, and none of the papers I'm aware of on cannabis and crashing have tried to work out where the cannabis came from, whether it was taken medicinally or recreationally. I mean, my understanding would be that medical users would be taking it regularly, and often the findings on regular users is that they're not as impaired, or probably not impaired at all, and they'd be taking it, I think, in doses that would be less likely to be impairing. So, I mean, I think just from common sense, one would suspect that the crash rate for medical users would be less. But I'm not aware of, you know, having looked at hundreds of papers on drugs and crashing, I'm not actually aware of any that look specifically at medical users of cannabis. I would like, is it possible for me to say one more thing about the 40% increase in crash rate?
Yes, please.
Okay. The important thing to notice is, even if it is 40%, and rather than perhaps the 0% that I suspect it is, the commonly accepted 40%, that is very low. I mean, alcohol at 0.05, the legal level, doubles your risk of crashing, so that's 100%. So cannabis 40% versus legal levels of alcohol, it's a lot less. If you look at other things, like the use of a motorbike increases the risk of crashing 30-fold. That's 3,000%. I mean, I think sometimes the focus is on the wrong things. If you look at all of the road safety problems, including other drugs, benzodiazepines, opioids, etc., cannabis is way down at the bottom of the list as far as crash risk goes, and that's if you accept the 40% and not my 0%. Obviously, if you accept my 0%, then there's no risk at all. So I think the crash risk from cannabis needs to be put into context. It is a very, very small risk compared with almost any other cause of concern to road safety people.
Thank you. Can I ask a quick question just to follow up on that, just in terms of from Mr. Timms, from whether is there, just based on what Dr. White has said, which was very useful, thank you, Dr. White. Mr. Timms, is there something that has outlines those risks in a chart, in a scale, in terms of the way in which Dr. White has suggested, in terms of the various risks of for example, taking prescription drugs, of alcohol at a certain level. Is there research that has shown that?
Well, I'd have to take that. We'd have to take that on notice.
Okay, I just thought you might know. That's fine.
Thank you. On the issue, I'm just struggling to reconcile the doctor, the matter of the 10 to 40% figure, and what's been said by other witnesses today. I'm not suggesting anything, but we're having comments like, for example, this was from Professor McGregor earlier today, that the crash risk goes up, but only marginally. So that was in his opening statement. And then later on in his evidence, he referred to the 10 to 40% figure, which we've been discussing in this evidence that we're hearing now. In your comments just a few minutes ago, there was, on this 10 to 40%, you seem to be repeating the 40% more than the 10%. In other words, I don't know whether that's because this research you're referring to is giving some emphasis to the 40% compared to the 10%. But you might appreciate it's a bit of a challenge for us who aren't expert in this area to discern exactly what the actual position is. And you're overlaying it now, and I'm not reflecting on you, but you're overlaying your evidence now with some further comments around bias, which I have to say Professor McGregor didn't comment on, and nor indeed have any of the other witnesses today. So I'm just wondering, how can you help us? And one final comment, that various witnesses have said also that there needs to be, far more research done to really, far more research, that's my phrase that I'm using, but more research to be done to try and understand what's going on here. So can you, perhaps that's more of a statement than a question, but you can see how there's a bit of a struggle here to understand what the actual position is, at least for me anyway.
Yes. My advice would be to consider that the most recent literature reviews and of a particular type called meta-analyses come up with about a 40% increase in the risk of crashing. The individual studies that they summarise have a wide range of risks. But when you do a thing called a meta-analysis and put all of those individual studies into the one conclusion, it comes out at about 40%, and that's what I concluded, and that's what I think other major recent meta-analyses have concluded. I think it's safe to say that the best evidence, without taking study biases into account, is that the crash risk is 40%. Now, my analysis is a little bit radical in that nobody else has tried to take crash risks into account in the way that Burns and I have done it. Probably for the practical purposes, until my work is accepted in the literature, which it's only just been published, it's probably best to stick to the 40%. If you consider that cannabis increases your risk of 40%, I think that's probably the conservative and sensible approach to take. And then it's a matter of getting that 40% into perspective. It's a lot less than alcohol at 0.05 BAC. It's a lot less than travelling 5k over the speed limit in a 60k zone. which doubles your crash risk. 40% is less than half of the doubled crash risk. So it is way down at the bottom of the list. It's a lot less than accepted crash risks for benzodiazepines, methamphetamine and other medical drugs, opioids.
We probably only have time for one last question. Lou, you didn't have...
Oh, just a quick one. Just by Mr. Timms. Just so we don't...
Yes, to Mr. Timms, yeah.
Mr. Timms, with relation to your research, you also get research from overseas when you're making evaluations to make recommendations?
No, we have connections with researchers throughout the world. We monitor conferences and proceedings globally.
And any recommendations or research from overseas?
Look,
other jurisdictions?
I think part of the challenge that this committee has is that patients who are prescribed cannabis as a medicine by their treating doctor have different motivations for using cannabis than other drug users. And I think that's part of the challenge, and I think that's one of the reasons why we've been fairly limited in our commentary so far. We don't particularly want to be drawn into broader issues, other than one has to be very careful when dealing with road safety, not to undermine what we call the pillars of road safety. That's certainly quite a challenge that you've got in front of you.
What are they, the pillars?
Well, the pillars of road safety, and I suppose probably going back to the start of the century, road safety experts started to move away more from the blame the driver perspective in all cases. There's cases where the road users are at blame, but we've started looking more at what they call the pillars, safe speeds, making sure that people are travelling at a safe speed, making sure that the roads are appropriate and the roads aren't setting people up to fail, making sure that vehicles are equipped with modern safety features, and also that making sure that people are using restraints, making sure that people have the level of education about road safety, such as that doctor-patient relationship, and making sure that they're not impaired in whether it be about alcohol or fatigue or drugs. One failure in the system can lead to a catastrophic result. I read, for example, that in one of the submissions, somebody talked about financial difficulties that a lot of patients are suffering. Well, financial hardship. People who suffer from financial hardship tend to drive older vehicles which don't have the modern safety features. If those people then live in remote areas, their travel speeds are likely to be higher. So if there is a crash, the crash is more likely to be severe. And then we have to look at trying to medevac them to major trauma centres. That golden hour of treatment the clock starts to run down. So that just sort of starts to give you an example of the spaghetti strands, as it were. You might think that you're talking about one area, but there can be other aspects of road safety that are affected.
Mr. Timms and Dr. White, thank you so much for attending this hearing today. We have unfortunately run out of time. The committee has resolved that answers to questions taken on notice be returned within 21 days, and the Secretariat will contact you in relation to the questions you have taken on notice. Committee members may also have additional questions which will be sent through. So thank you for joining us. And to the committee members, we're just going to stay live while we get the next witnesses. So,
Doctor, thank you.
Keep that in mind. Yeah.
Thank you very much for the opportunity.
Thank you, Doctor.
Thank you, Dr. Watt.
Yeah, good.
Good afternoon. Do I have Mr. Christensen online? Mr. Christian, sorry. Mr. Shane Varco, can you see and hear me okay? What? I can indeed, thank you. We are broadcasting live at the moment. I'm just doing a quick test. Mr. Gary Christian, can you see and hear me okay?
Yes, I can hear you now. I'm just trying to get my camera up.
We can
see it. Just go onto another screen, that's all.
We can see and hear you fine. Thank you.
All good. Again, Shane.
Hey, Gary. Excellent. We'll get started, so I would like to welcome our next witnesses. If I could ask each witness to please state their name and position title and swear either an oath or an affirmation. We'll start with you, Mr. Christian.
Gary Christian, Research Director for Drug Free Australia, and I would swear I'm going to fire the oath.
Thanks. If you want to read the oath now, swear the oath. Thanks.
Okay, sorry, I haven't got that in front of me. Do you have to read that for me?
Yes, I'll just read each line, and then if you could repeat it after me. So, I swear that the evidence now.
I swear that the evidence now.
About to be given by me.
About to be given by me.
Shall be the truth.
Shall be the truth.
The whole truth, and nothing but the truth.
Nothing but the truth.
So help me God.
So help me God.
Thank you. And Mr. Varco.
Shane Varco, I'm the Executive Director of the Delgado Institute. I will read the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you. Mr. Christian, did you have an opening statement that you wish to share with us today?
Yes, I'll be very quick and keep it to 2.5 minutes.
Thank you.
Australia prides itself on following only evidence-based drug policies. I'll repeat that. Australia prides itself on following only evidence-based drug policies. So on this question of cannabis-impaired driving, what assertions should be immediately cast aside for lack of genuine evidence? Well, the sheer bulk of submissions to this inquiry, as I read them, rely on medical cannabis works for me. That's what they were saying. That's their reason. But we all know that it is irrelevant, and totally irrelevant, because hundreds of thousands of Australians would attest that alcohol is very effective in drowning their worries or their anxieties. Drug driving does damage to others, and so that's the issue, not personal effectiveness. So observational studies are the arbiter and nothing else. Now, I see it argued that other countries are doing this, but for every country that is doing it, there are 190 that aren't. And then, did they decide on the emotional "it works for me" argument? That's got to be asked, which has great appeal with the public, but legislators should be more diligent. It's also argued that morphine should be should be used as precedent in New South Wales, but most everywhere else doesn't do it, and there is little parity between cannabis and the broad continuum presented by mild codeine use on one side and high powerful morphine on the other. So what science should we rely on? 62% of Australians use medical cannabis for chronic pain. That's the bulk of people looking for an exemption, of course. Observational studies of 110,000 medical cannabis patients show that cannabis reduces chronic pain by 30%, making it only ever useful as an adjunct to other drugs like morphine, and it is ineffective when it's used alone. Now, we have given you evidence in writing that cannabis used with other drugs have additive and even synergistic effects on driving. Most of the genuine cases amongst those 62% using cannabis for chronic pain are going to be using two drugs, not just cannabis, but cannabis and morphine, both impair driving, creating far greater dangers to the public than the use of single drugs alone. So 62% should be the end of this matter, shouldn't it? And even if the bulk of that 62% are pretending to suffer chronic pain and they're using it as a ruse to legally use cannabis recreationally, they are not genuine medical cannabis patients, and laws should never be made in favour of such recreational users. That's the end of my statement.
Thank you. Mr. Varco, would you like to deliver an opening statement?
Certainly. Thank you for the opportunity, Senators and Committee. Thank you for the opportunity to present here with you today. The Delgado Institute is one of Australia's longest-standing not-for-profit public health education charities, and as part of our multifaceted service to the Australian community, we also are the overseers of the People Against Drink and Drug Driving initiative, which was commenced in the 80s. Concerns, practical wisdom and best practice. From the outset, we reiterate our concerns outlined in the submission that a vote medicine framework has been, albeit inadvertently, permitted to undermine best practice clinical protocols of the TGA. The lack of fully vetted clinical trials on efficacy and side effects of the new offerings of medical marijuana in the market is concerning. To amend our original submission, the only cannabis-based medicines that are properly pharmaceutically vetted are Epidiolex and Sativex. Any product touting therapeutic capacity must be fully vetted, commencing with exhaustive clinical trials and then a thoroughly regulated and relentlessly scrutinised deployment. In this context, we are concerned that the new Vote for Medicine framework is creating both present and future public health and safety liability. Cannabis driving does not have to be one of them. THC formulations and various THC derivatives, including THC that's isomerized or converted from CBD, must be considered also in these deliberations. These derivatives are also being made almost 3 times stronger by the escalation process. THC and all its derivatives are what get people high. THC is a psychotropic toxin that may or may not just cause drowsiness, but we know from a growing body of research it is a contributor to psychotic breaks of various manifestations and is now front runner for substances that can transition a psychotic episode into a chronic psychotic disorder. We contend that exempting these formulations from drug driving breaches is a serious public safety issue. Finally, recently published peer-reviewed research, which has only just been released, and the reason why it's being tabled here not earlier, must also be weighed in these deliberations. The paper Effects of Cannabis on Visual Function and Self-Perceived Visual Quality reveals the following. Cannabis consumption has a negative effect on both visual function and driving performance. We have found significant correlations between certain visual and driving performance parameters, particularly regarding driving stability. Thus, our results highlight the importance of parameters such as visual acuity, contrast sensitivity or stereo acuity, which play a key role in maintaining the vehicle in the lane they are driving in properly. Moreover, our results suggest a lack of awareness of the risks associated with cannabis use in driving, given that a considerable proportion of participants have driven after using cannabis. There is therefore still a considerable need for awareness raising and information campaigns added to the general public, as well as for research that provides adequate insights into how the drug affects both short and long-term vision and the ability to drive safely. My remarks end there. Thank you.
Great. Thank you, Mr. Varco. Could I ask you to also table the journal article that you made reference to in your opening statement, and the committee staff will circulate that to members?
That was submitted about half an hour or 45 minutes ago.
Great. Thank you. Questions from committee members?
Yeah, I'll kick off. Thank you. It's Kate Fairman here. I just wanted probably a question to both of you, because I think you've both done it in your submissions. But I'm just wondering, is there a reason why throughout your submissions, when you refer to medicinal cannabis, you put the word medicinal in quotes? So is it that you're disputing the medicinal effects of cannabis entirely? I'll start.
I might just address that one, because it is fairly well known that cannabis, and I've already cited that, is not effective for chronic pain. That is established with 110,000 patients in a review done by Australians and published in Pain. And so there are a considerable number of people who are using this as a ruse. The reason that we know that is because we know the profile of people with chronic pain. It's usually ladies who are around 80 and men who are in their 70s. When you look at the people who are signing up for chronic pain in America, where we have good data, their average age is age 32 and 70% men. The two profiles do not match chronic pain. And so we know that there is a considerable amount of ruse being used so that people can use medical cannabis as a way okay to have recreational use, but make it legal, and for that reason.
If I may, Senator.
Yes, please.
Yeah, sorry. Yeah, look, just further to those remarks, again, nomenclature matters, and I think in the current conversations around this often hijacked platform, we are seeing a misuse of titles and names. As I read in my opening statement, there are 2 pharmaceutically graded medical cannabis offerings in the marketplace that have been fully vetted, and we have no problem with those. In fact, Sativex, as one of the brand names is known as, has been on the market for nearly 30 years. And again, fully vetted with all its understandings of its potential benefits and its harms and side effects. Again, Epidiolex, GW Pharma spent, and with the responsible pharmaceutical, spent I think 13 years and $1.3 billion researching this properly, and didn't just concoct it in a farm in Colorado and call it Charlotte's Web and say it's medical because it makes me feel better. So the offerings that have not been fully vetted through the clinical trial process that should be watchdogged by TGA, not hijacked, TGA hijacked by this Vote for Medicine framework, should make very clear what is medicinal and what is just named medicinal, hence the parentheses.
So, Mr Varco, you also state that this bill would give a free pass to recreational users, but the bill specifically, it specifies that a user must have taken the drug in accordance with medical advice and only creates an exemption to Section 111 of the Act relating to the presence of THC, not Section 1112 of the Act relating to impairment. So, the bill obviously says that someone who is noticeably impaired is not charged. So why do you say that this would give a free pass to recreational users? Particularly because they need to have been a medicinal cannabis user.
Well, again, depending on which derivation of cannabis is being used. And again, those two medications that are properly fully vetted, and one is for Dravet syndrome epilepsy. Now, one would imagine that a person suffering with that kind of shocking condition wouldn't be driving anyway. And Sativex is used regarding spasticity. Get it out of there. Regarding MS, sorry, I do apologise. And and some of these formulations can be used with stage cancer patients who are having difficulty with chemotherapy as an appetite stimulant. And none of those people should be driving. So when it comes to THC in the system, determining where that THC came from, and if one has a pass with driving with THC, then you say, oh, I've got a medical certification for this. Here's my prescription. I'm just using it according to that. The THC is in their system, the THC is an impairment. And as I've just read through the latest research, they don't even realise they're impaired. And the whole idea, and we've been involved with people against drink driving and now drug driving for a long, long time. And the anecdotal evidence around those who can maintain a capable driving ability with a blood alcohol content of 2.5 is unacceptable in our culture, even though they say they can do that and demonstrate it by doing it on the road. We've got to be concerned that we don't enable this kind of backdoor to be created. And by simply leaving cannabis in its current place, we're not going to have the problem of people driving with THC in the system. It's as simple as that.
I might just add that if you're a doctor who is prescribing cannabis, you cannot prove that the pain is real. And that's why it is used as a ruse. So PTSD, there's no objective way of being able to establish certain conditions. And those ones are targeted by recreational users who want to use medicinal cannabis as their ruse.
Done.
Yeah. Can I ask, either organisation, do you support a blood alcohol limit of 0.00 for driving? So is that a position that you have in relation to alcohol, that the law should be that you cannot consume any alcohol and drive?
Yeah,
I'll jump in on that one, if I may, Gary. Look, we've certainly advocated for that for a long time. In fact, we pushed for, because in Europe there are places that have already instituted that. And being the long-term advocates for a zero tolerance when it comes to driving. But there was a debate and held about, and forgive me if I'm not completely accurate on this committee, about 10 or 11 years ago, that 0.02 would be a better option for the simple purpose that enables a person to go out for a nighttime economy, have one glass of alcohol only with a meal, still be under that 0.02 limit. But we also know that at 0.02 there are still liabilities to the driving capacity. So we certainly advocate for zero alcohol use and driving, absolutely. We don't have a problem with that.
Thank you, Mr Varco.
From the Drug-Free Australia point of view, there is a difference between alcohol and cannabis, which we sent in amongst the 30 documents that you have referenced in our submission.
So it's completely acceptable to you that people would drive. It's completely acceptable to you that people would drive with a blood alcohol limit of 0.5, the current legal limit, but you have a zero tolerance to THC.
Look, I think I'm closer to Shane's position, but what I'm just pointing out is that there is a difference. There is a relationship between dose and alcohol impairment. That's not true with cannabis. They work differently.
What about, and again to both of you, what about people taking legal prescription medications such as benzodiazepines and other opiates? Do you also support an absolute blanket zero tolerance to the presence of those drugs? Obviously, they're currently excluded and people are able to legally have them in their system so long as they're taking them consistent with their prescription and in consultation with a medical practitioner. That's currently legal. Your position presumably is that that should be illegal, Mr Christian?
Yeah, we do have concerns about drugs and driving. If you look at the New South Wales report, I can't share my screen, but well, maybe I could. But if you have a look at the New South Wales report on drugs which are involved in accidents, benzos and are very much implicated. I think there needs to be a tougher position on certain of those medications.
Sorry, Gary.
Yeah, no, that's what I had to say.
Okay, Senator. Yeah, look, it concerns different dynamics, both of idiosyncratic responses to substances and their nature. Opioids commonly create a drowsiness, which is obviously a concern for anyone driving. Anyone who's driving under the influence of drowsy-causing substance, which all these medications, I believe, is what I've seen both anecdotally and in my prescription viewing, is that those who are prescribed these drugs are told not to drive, operate vehicles, and that should be upheld, I think. But remember that, as I said before, THC, not necessarily CBD, although CBD can be converted into THC derivatives. THC is a psychotropic toxin. It has a different impact on the psychobiology of the taker of that substance. That is not just about drowsiness. It can be all sorts of manifestations. And again, it is idiosyncratic, understand that. But we now know that cannabis, I'll say it again, cannabis in the high-end use of THC is now the front runner of transitioning from a psychotic episode to a permanent psychotic disorder. That's in the literature. And that's a concern. Any legislation that promotes the use of that kind of substance in charge of a vehicle is very concerning. Now, we see alcohol weaponised, vehicles weaponised by alcohol all the time. Why would we add another potential substance to that regimen and cause that public safety issue? That's a concern we have.
But obviously, as Mr Christian said, we know that people who are legally taking benzodiazepines and other prescription medication can be impaired. They are currently not caught by the section of the Road Transport Act that we're dealing with. They can be subject to the DUI offences in another section, but that they are currently completely exempt, even though there may be traces of those medications in their system that could be operating in exactly the same way. How do you reconcile that inconsistency?
I just thought I just did. Sorry, I didn't make myself clear enough. That there's drowsiness and psychotropic intoxication, and the psychoaffective dynamic of THC is different to other substances. Now, this is a concern. Like the THC, particularly high-end THC consumption, does create this problem. And we're not talking just drowsiness. And again, we shouldn't be operating vehicles when we're drowsy or our faculties aren't at full measure. I don't have a problem with that. And people do drive. They shouldn't. They do drive. But when it comes to a psychotropic toxin like cannabis, like THC, sorry, not cannabis, derivatives like CBD, THC, we're talking about a different manifestation and a different impediment. And I think that's where the debate gets a little bit skewed. So just lumping them all in together, it's, oh, well, I can drive drowsy, but can you drive stoned?
But presumably someone who was in that state that you have described would obviously be subject to the DUI provisions in section 1112. If you're driving in that state, you're clearly under the influence of a substance that you shouldn't be, just in the way as if you're driving, you know, while you're zonked out on benzos. That is all illegal under section 1112 of the Road Transport Act. Section 111 has got nothing to do with whether you're in a psychotropic state, whether you're, you know, kind of a zonked zombie. It's only related to the mere presence of a substance in your system. And
sorry, as we've said, there is a difference between these substances, and THC works in a different way to say alcohol. And so, you know, we're particularly here talking about THC and an amendment for an exemption, whatever. And the point that we've made is that people, the bulk of your people are going to be using, 62% use it for chronic pain, whole other group use it for PTSD, and it is, you know, you're going to have more than one drug.
I mean, in relation to that, your concerns about people falsifying PTSD, chronic pain and other mental illnesses in relation to access to medicinal cannabis, again, I mean, putting aside the fact that that's relatively offensive to a number of the military veterans that have provided submissions to us, that is potentially the case in relation to other prescription medications as well, which they can legally get access to and legally drive. So again, specifically in relation to your concern about people falsifying mental illness, falsifying PTSD, falsifying chronic pain, if that were genuinely a concern, they were able to do that to access opioids and benzos and then drive legally. Why is that not of concern, more concern to you?
Yes, we are concerned. If they are going to impair their driving performance, we obviously have a concern.
I'm going to go to Greg.
The other concern here is that we are still looking for the pharmaceutically rated, clinically proven, not any data, medical cannabis-based medicines, pharmaceuticals for PTSD, for example, are still not in the marketplace. Now, again, we've got this new mechanism where genetic data now drives a lot of the assumptions. And now we know from a lot, and we can provide a lot of literature around the negative impacts that cannabis has on PTSD and the amplification videos as well. So there's a lot of evidence on the other side of that coin. But again, it's the nature of the psychosis potential of this substance that is different to the other ones. That's the biggest concern. And the use and misuse of this, regardless whether it's for recreational purposes or not, is concerning when one is behind the wheel of a car or driving a work vehicle or a piece of equipment or plant in a work situation. It's concerning.
Well, obviously the same would apply to alcohol, but I do appreciate, Mr. Varco, that you have a very consistent position on that, and I actually respect that you have that. I'll over to my colleagues
Mr. Donnelly.
for questions.
Thank you. Thank you, gentlemen, for agreeing to appear today. One matter that's been exercising my mind is sorry, you may not be able to see me, it's Greg Donnelly, is the matter of trying to define with some specificity the matter of impairment. Yes. The term is used in a sense of having some certainty around what it means. With respect to some of the evidence that's been provided today, it's been suggested that it's almost almost obvious what impairment is, and that people will be guided by that sense of knowing what it is. In other words, they know when they're impaired, and that will be the brake that will stop them getting behind the wheel when they're impaired. But I'm just wondering whether the evidence about, and this does not have to specifically refer to medical cannabis, but the ability for people to understand when they're impaired and them making that critical decision not to get behind the wheel. So I invite you to just reflect on this issue of impairment and actually the ability to be clear about what it is, and people in real terms exercising that judgment about not getting behind a wheel of a vehicle when they're impaired.
Can I just speak to that one? And in our submission, number 26 of the Medical Journal Studies and Data that we sent you addresses that, and people don't have a correct understanding of their impairment. That's even with alcohol and with cannabis, both of them.
Yeah, Senator, thank you. Yeah, look, it's become such a subjective criteria that one of the reasons we introduced a blood alcohol limit, and we know the history of this particular framework quite well because it's part of our stable, and it took a long time to get BAC into the marketplace. It was a long fight, hence we are very concerned about any mechanism that's going to let that standard slip, because we were seeing incredible issues around road toll because people believe that they can drive a car and when they're drunk. And as I said, there was an incident, again anecdotal. Let's throw an anecdotal scenario into the mix here. They're popular in the current context. There was a Roman Catholic priest in Griffith who was picked up driving a car. He was meandering a little bit, just a little bit, and a little slower than normal. He had a blood alcohol reading of 5. He was clinically dead. And he believed because he was a chronic alcoholic, basically suffering with Wozniacki's disorder and Karsdorff syndrome, both quite debilitating, he could drive, and he actually got in the car and believed he was perfectly fine. Now, when you add THC, now again, alcohol has its own issues with the brain chemistry. When you add any psychotropic toxin that has the potential to create psychotic episodes, and this is a concern, this is a distorted reality, not just a sense of confidence or drowsiness, but a distorted reality. And as I read in my opening statement, we now know that these drivers don't understand that their vision is impaired. They don't believe it, they don't understand it. And that's the new research, they don't get it. So when they said, I'm fine, I've just taken my medicine, according to some of the data out there, if I've waited, let's say 12 hours since I've had my THC, or even 7 hours, or I think one study said, 5 should be okay on a personal level. So if I've had my THC medicine, I wait 5 hours and then drive, I should be okay. But according to this new study, people don't understand the visual impact that's been given to them. Now, when you can't understand it visually, then you've got a serious problem when you're behind the wheel of any vehicle.
Just got one more question, if I may. We heard earlier today witnesses from the Lambert Initiative, and they provided a detailed submission, which is quite helpful. But I'm just inviting you to comment on this because I'm wondering whether there's a timeline that you might be able to place on this, or some thinking around what it would take to identify something. So it's on page 3 of their submission, and I don't want to be appearing to reflect on people who've come before the inquiry or provided evidence to the inquiry about the therapeutic effect of medicinal cannabis. But in the Lambert submission, towards the bottom of page 3, and I won't read the full paragraph, it says THC products have demonstrated efficacy in treating a number of debilitating conditions, and it goes on to talk about those. But interestingly, concludes the paragraph by saying, however, the quality of this evidence is still questionable, with more high-quality clinical trials required to confirm these effects. I was just somewhat unsure about what they're actually saying. In the one sense, they're acknowledging that there is some effect that appears for some people to have a way in which it may well ameliorate pain and other effects of perhaps a condition they may be experiencing. But really it's qualifying at the end by saying there needs to be, well, they use the words here, is still questionable, which seems to be a pretty strong statement made by, you know, an organisation like the Lambert Initiative. Can you comment about this issue?
Back in 2017, the National Institutes of Health, you know, which is kind of the premier health research body in the United States, looked into all of the different journal studies for, you know, various medical conditions. And it actually rates, you know, gives you some idea as to whether the data is, you know, reasonably conclusive or totally inconclusive or fair to middling. You know, they make those judgments on a condition-by-condition basis. And I think that would be the place to turn, to be honest. That's, you know, I had 34, I think it was 34 researchers, many of them pro-cannabis, you know, who were on that committee that did that massive review.
Senator, thank you. I think one of the interesting realities of the emerging space we're in when it comes to clinical trials, there's been a new term that's emerged in the last 12 to 18 months called anecdata. And it's a wonderful little concoction between anecdote and data. And what we do is we throw it in the mix and we add pathos to a passionate pathos to a series of personal stories that, as we saw with Charlotte's Web in the US, when they were feeding this concoction to Dravet syndrome epilepsy kids, which were not at that stage diagnosed, and they said their fitting stopped. Look, it's magical, it's wonderful. Now, when you see a fitting child, it's awful. It is just awful, and you want it to stop. But the short and long-term harms of that substance on that child have still not been clinically verified or validated. And that's one of the reasons why these studies talk about and use anecdata, which concerns me, as Gary's intimated. We are looking at hard clinical trial evidence. GW Pharma, again, did the right thing. And they come up with a PDLX, which is their legal form, pharmaceutical form of Charlotte's Web, if you like. And mind you, what's interesting to note, that is as a formulation for Dravet syndrome epilepsy, which is a very small window, and it's an awful condition, please, awful condition. And I understand why people are desperate to have at least symptoms abated, is that it is now a fourth-line treatment only, and it has a 25% efficacy. And that is a fully vetted, clinically trialled, cannabis-based medicine. Now, our concerns are, as I said, Lambert's actually stating publicly that we need more trials. Now, cannabis was touted to be the new miracle drug since 1970. In the 1990s, it was pushed as the new medical marijuana. Now, we've had 30 years of trials, 30 years of stories, and we're still coming up with a product that does not do what it claims to do. It's supposed to be a panacea of all ills. Its placebo effect is breathtaking. And we've asked that organisers and researchers focus on the placebo effect of cannabis. So you don't have to ingest THC or CBD to get the impact. You can harness that scientific phenomena. So our concern is that with Lambert, we need to have proper clinically trial researchers. But again, if you put a vote for medicine framework in, you get this. We don't have to have clinical trials. We just have stories, and then we just go, we've got to change the rules. That's a concern. That's a real concern.
Any Further questions from committee members?
I mean, yeah, just to follow up on that, Mr. Varco. So one of the things that Lambert also talked about was what they called their AMBER trial. And I think you are in agreement with them that more research is useful. And they talked about that, trying to, come up with a comprehensive way to, measure specifically the impact of driving impairment for medicinal cannabis patients and wanting to partner with the government on that. I mean, that is something that you would be supportive of?
Of course.
Yeah, excellent. And I mean,
like any drug, we need to make sure that we understand. Going back to the previous senator, sorry to jump in there, but previous senators' comments about impairment, we need to establish a baseline. We've done it with alcohol. We call it 0.05. Personally, I'd like to see it. I think as done in some Scandinavian countries, down to 0.0 would be great. But with this, we need to establish clear, evidence-based. Again, across a broad section, because again, you're going to be dealing with various idiosyncratic responses in people. And so, you've got to make sure there's a vast array of clinical trials done on a vast demographics to ensure that we come up with the best definition of impairment before we release or unleash this pass to drive a vehicle under THC influence.
And we all love research, so, what they're wanting to do, that's well and good. What they're not addressing is the point that we have made, is that 62% of medicinal cannabis users are there for chronic pain. It is two drugs which are generally going to be used, both of them debilitating of driving. Is that going to be addressed? And, that's going to be a very important consideration.
One of the things that, again, they talked about, to you, Mr. Varco, but either can comment, is it is always going to be difficult to measure impairment for, THC impairment in the same way that we measure alcohol. I mean, it's just not, particularly in a kind of roadside testing model. You're not taking everyone off to get a blood test all the time. It is always going to be difficult to find a test that does genuinely measure impairment in that way, in the same way as it does with blood alcohol for THC impairment. And so the use of sort of sobriety tests or field sobriety tests as one way to try and measure the impairment of someone. Is that something that, you think could play a role, where we try and develop a comprehensive framework that allows police in a roadside setting to try and test someone's impairment? Do you think that could be useful?
I think the dangers are too high. As we pointed out a number of times, your bulk of your users are using it for something that requires multiple drugs. And I think it just makes the question that you've asked moot.
I mean, in a way, actually, it sort of tries to address that, in that if someone is taking THC along with high-dose codeine or morphine or something else, and that is interacting in their system in a way that is impairing them, they should not be driving a vehicle, some kind of sobriety test or roadside test which bears that out, in fact, would allow you to identify people committing an offence and people who are not in any way impaired, potentially. I'm just positing it as a potential solution.
Can I speak to that, Senator? Yeah, look, it's a fair question. And again, the history of BAC in this country, and again, we have the records of this, and having auspiced this for now nearly 30 years. All those roadside sobriety tests were superseded by the BAC test. In fact, when it was created, Australia was one of the countries that fought hard against having it in, and the police thought it was going to be a bit of a joke. But once they got it in, it had remarkable outcomes. Now, my concern is that if we can create, and through the research, and going back to the previous statements, if we can create research that develops a clear understanding of what impairment is under THC usage across a wide range, then that can be an application that can be then used to bring about a sobriety test. So therefore, for example, it might be, again, please, I'm being arbitrary here, so don't quote this figure. Let's say 0.03 grams of THC in the system is the impairment level. Now, at the moment, that's difficult to do because that's one of the issues. So if we can arrange, if the studies and research could bring that about, that would be as handy as a 0.05 thing. Of course, if that cannot be done for whatever reason, that cannot find that line, then the impairment process is going to be very subjective. Again, as I said, we have an individual driving a vehicle at 5, not 0.05, 5, and being actually able to get in, start the car. This person was clinically dead. So again, our concern is that the subjectivity of this and the roadside testing, and people can put their fingers on their nose and walk a straight line, you're fine to drive. We just read that visual capacity, that will not test visual capacity, that will not test their impaired vision.
I understand your point, Mr. Varco, about people's inability to self-assess their impairment, but that relates not only, as you said, to alcohol, for which we have a clear test, not only though to drugs like THC, to opiates, to benzos, but also to things like tiredness and risky driving. You know, we allow people to get driver's licenses and get behind the vehicles, the wheel of very, very dangerous machines that kill them and other people, being cars. And we say, don't do it when you're tired. Don't go, drive in a way that's dangerous or you can't control the vehicle. Be extra careful when it's raining, those kind of things. And we do allow the drivers of the vehicles to make assessments about their own state in a range of circumstances. Yet in this area, we don't. We don't allow them any capacity to say, I am completely fine to operate this vehicle. It's a blanket rule. So I guess that's what I'm trying to tease out. What's the difference between saying, if you're sleepy, don't drive? So I wasn't feeling sleepy at all. I just swerved on the other side of the road.
So on that logic, we would go back to alcohol and say that a person who feels that he can hold his liquor and his own self-assessment should rule. I don't think there's any reason to go that track. The other thing is I again refer to the medical journal study number 26 that we had within our written documentation, which says there's no real relationship between blood THC levels and impairment. Differs. Everybody's metabolism differs, a bit like ecstasy. So, it's all over the shop. I don't think that's going to work for us.
Again, at the risk of falling afoul on that, that argument sounds a little bit like the argument I hear about sugar and cocaine. Often sugar is bad for us, and now we're in a place in some sectors where we stigmatise chocolate eaters to justify the use of cocaine. I think there's chalk and cheese between being tired and your faculties being undermined because you're tired, and sure, you shouldn't drive, no argument there. But actually having a substance that does impair in your system and having taken that substance and know you've taken it, that's why we have the blood alcohol content. That's why it'd be great to have a THC content. That'd be, those kind of places. And an opioid, benzo contents. Okay, we've now defined that if you have an opioid content of less than 0.0 grams in your blood, you're okay to drive a car. But if you haven't, then we're going to fine you for driving under the influence of a substance. I have no problem with those mechanisms, but to detune those and devalue and derail the current mechanisms and undermine them, I think that is really concerning at the moment. That's why this process has to be very carefully managed, because we do not want to go backwards after decades and decades of fighting to get road safety on a better track.
We have unfortunately run out of time. So, Mr. Christian, Mr. Varco, thank you so much for joining us today. We'll be in touch with regarding any supplementary or questions on notice. I think there was one or two, maybe. And we'll get back in touch with you if committee members have any additional questions as well. So that's it for us now.
Thank you for the opportunity to be here today. It's very much appreciated.
Thank you. And we now have a lunch break until 2:15. Yep, we're live. Thank you, everyone, for joining us today. And I'd like to welcome all of our next witnesses. And just a reminder to the committee members that when we're asking questions, if you can identify yourself as well, in case the people online can't see you or know who you are. So with each of the witnesses, could I ask each of you to please state your name and position title, and swear either an oath or an affirmation. We'll start with you, Mr. Barnes.
Thank you very much, Chair. My name is Greg Barnes, SC. I am a barrister, but also a spokesman for the Australian Lawyers Alliance. And I swear that the evidence I'm now about to give shall be the truth, the whole truth.
Thank you. Mr. Cowdery.
Thank you, and thank you for the opportunity to attend online. My name is Nicholas Cowdery, AOQC, and I'm appearing as a spokesperson for the New South Wales Bar Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me is the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Kalalazada.
Thank you, Chair. My name is Rose Kalalazade. I'm a barrister. I'm here in my capacity as a member of the Bar Association's Criminal Law Committee, and I solemnly and sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Irvine.
Thank you. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. And Ms. Farrugia.
Thank you, Chair. My name is Amy Farrugia. I'm a lawyer, and I'm here in my capacity as the Vice Chair of the New South Wales Young Lawyers Criminal Law Subcommittee, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Great, thank you. I'll call for opening statements. Mr. Barnes, did you have an opening statement?
Thank you, Chair. Very briefly, we've made a submission to the committee, and in essence, the experience of our members, and including my own experience, although I don't do much of this now, is that drug driving laws are inherently inequitable in many respects, particularly in relation to medicinal cannabis patients. I've given advice to South Australian MPs in the area. I've also read some decisions of former magistrates that help them on this matter. And probably most importantly, I practice partly in Tasmania, where in fact there is a defence, not so much a defence, an exemption, if you like, from drug driving laws if a person has a prescribed drug came from their medical practitioner, by the way, enforces legislation.
Great, thank you. With the New South Wales Bar Association, was there one opening statement, or you both? Yeah?
I will attend to that.
Okay, great, thank you.
Thank you, Chair. The Bar Association has set out its position in the written submission to the committee of the 4th of May 2022. In short, the Bar Association supports the enactment of legislation to amend the Road Transport Act to provide a defence for those who are legally prescribed cannabis from the offence of driving with a presence of a prohibited drug in their system that is legally prescribed THC. The Bar Association recognises that currently if THC is detected in a driver, they face significant fines, so $2,200 for a first offence and $3,300 for a subsequent offence, and also potential licence disqualification. And if the matter proceeds by way of a court attendance notice, there are costs associated in the criminal justice system, including the allocation of court, prosecution and legal resources. So in essence, the Bar Association Association supports the introduction of a defence that is consistent with the current defence available in Section 111, subsection 5 of the Act with respect to the presence of morphine. That is, that the accused would be required to prove on the balance of probabilities that the THC in the accused system was as a result of lawfully consumed medicinal cannabis. Thank you.
Great, thank you. And the New South Wales Young Lawyers, was there one or two opening statements?
One opening statement.
Thank you.
Chair. In summary, the Criminal Law Subcommittee is in favour of the proposed bill that we're here to discuss today. We see it as a sensible, a logical extension of the existing exemption for medically prescribed morphine. We are of the view that certain clarifications could be made to the bill to remove any potential ambiguity or any difficulties in the ultimate implementation of the bill. And then finally, we have decided that we are not in favour of imposing any further limitations to the applicability. That is our summary, and we're prepared to.
Great, thank you. So I'll now hand over to committee members to ask questions. Mr. Roberts.
Thank you, Chair. I might direct my question to you, Mr. Barnes, in the first instance. We're here to look into today the provisions of the bill, and I know it's presumptuous of me, but I assume you have a copy of the bill in front of you, or?
I have read the bill.
Okay. Well, I'm not going to take you to a specific line or anything, so it's not a trap question. Look, it's my proposition, and I look for your comment, and perhaps yours too, Ms. Kalalizada. I apologise for my pronunciation.
That's fine.
I believe the bill is deficient in its silence in a number of areas, and I'll explain that to you. Let's take it to the practicality of a roadside random drug test, where I get wheeled over by the police and they say you're subject to a random test. I do the saliva test and I return a positive to THC. In the bill, it doesn't say what happens from there. It makes an exemption similar to the morphine, but it doesn't say whether certainly it puts the onus of proof back onto me, which is a reversal from the usual practices, you know, of he who asserts must prove, but it doesn't say whether I need to prove it to the police there and then on the spot, or whether I need to appear before a magistrate or a court or some form of tribunal and prove it there, and whether it's beyond reasonable doubt or whether it's on balance of probabilities, etc. So my concerns come from this, that if it is to prove it to the police on the spot, how do we do that? Is it the production of a doctor's certificate, perhaps, or a copy of the prescription itself? Taking that as the example, it's possible that production of a doctor's certificate or the prescription could be a masking for the illicit use of cannabis. I may well have a prescription for medical cannabis, but if I get stopped at the random test and I prove positive to cannabis, where there's no proof that I haven't smoked a joint or pulled a bong or whatever expression you want to use prior to driving the motor vehicle. So I have concerns about just providing it to the police on the spot. If it was provided to the police on the spot and the police were to accept that okay, this is medicinal cannabis without being aware of the full circumstances, the driver was then allowed to drive down the road and had an accident which somebody sustained a serious injury or fatality even, there would be some sort of vicarious liability on the police then, because they've got knowledge that this person has THC in their system, but they allowed them to drive. So I'm looking for some comments from you folk as the experts in law where you see some issues, or do you see any issues with the propositions I've just put forward?
Thanks, Mr. Roberts. You asked me first. I might be able to assist by telling you what happens in Tasmania. In our submission, we've set out the Tasmanian provision. So what the Tasmanian provision does is it doesn't reverse the onus. It doesn't make it an offence. It simply says if a person who drives a motor vehicle while a prescribed illicit drug is present in their blood or oral fluid is guilty of an offence. Then then says that you don't commit that offence if the prescribed drug is obtained and administered in accordance with the Poisons Act 1971. The way it works in practice, as I understand it, is that people who are prescribed medicinal cannabis by their doctor will, generally speaking, have that prescription with them, for example, in their vehicle or on their person. And there's certainly been cases in Tasmania that I'm aware of where police have simply accepted that on the spot. Generally speaking, what police would do, because you don't lose your licence, because you've got THC in your system, automatically it would only be if it was something where the driving was the issue rather than the presence of drug or alcohol. Sometimes what happens is that they will, in fact, indicate that they're going, you might receive a summons. People then get another letter from their doctor saying, look, Bill was prescribed this, takes it in accordance with the prescription, and that's shown to the police, and then the summons is either not issued or withdrawn. So it's a bit of a mixture in terms of when that is done. I might say that the Tasmanian provision is much broader, though. It's not confined to medicinal cannabis. It's in fact any drug that is prescribed or administered. And I think now, just to side with ketamine and MDMA and psilocybin and other drugs increasingly being used for PTSD, that's probably going to become something that Parliament will need to look at. But for the moment, that's the way the Tasmanian provision works. So in essence, if you can show them that you've got a script, then and it's a current script, then you're entitled not to be charged with that particular offence. Generally, you don't have to wait for it to go to court. You can do that because it's not in fact an offence. You have not committed an offence. Now, when it comes to the issue of how does the doctor know? I think the question was, how do you know that a person's taken it in accordance with the... I mean, essentially, unless you've got a police officer standing with you while you take it, or you've been monitored, you're never going to know that. But what we're talking about here, of course, is cases, we're not talking about cases where people are driving under the influence. What we're talking about is simply that they've got out of the car, there's been a lick test, they say you got THC. So it doesn't save you, if, for example, it's erratic driving and police pull you over. I hope that helps.
Clarification on what he said. If I cannot... sorry. I just wanted to, sorry, it's Kate Fairman. Can I just get just a quick clarification in terms of what Mr. Barnes just said? I've just got a question. So just to clarify, when you were saying that the police if they pull someone over in terms of how the law's operating in Tasmania now, it's an offence in terms of impairment. You might have been driving erratically or whatever, but it's not in terms of traces. You were referring to Tasmania in terms of how the law is now. Is that correct?
No, what I was saying was if you're pulled over because you're driving erratic, and they won't charge you. The fact that you're on medicinal cannabis and you've got a prescription to help, the nature of your driving is the issue. This charge is simply that case where you get pulled over, random lick test, you've got THC, you pull out of your the vehicle, here's my prescription from my doctor, police will, as I understand it, generally accept it, and if they don't accept it at that point in time, they'll accept it later. I might say there's been a policy here, quite a more liberal policy here when it comes to medicinal cannabis generally. So people, for example, are found with cannabis in their household, even if it's not medically prescribed, if it's just plants, but they've got a letter from their doctor saying they're using it for pain relief. There is a de facto policy of Tasmania not to charge people in those circumstances.
Other questions?
I think go back to Mr. Cowdrey was about to
yes.
speak before I interrupted.
Cowdery, sorry for interrupting before.
I didn't mean to interrupt there, but I thought one of the Bar Association representatives, I might comment on the initial question. The bill in its presently intended form, I think in practical terms, would result in a situation like this. Somebody is pulled over, tested, positive for THC. Police would issue a court attendance notice. It will then be open to that person to put forward representations, police, establishing the defence or the exemption. If the police accept that, that's the end of the matter. If the police don't accept it and it goes to court, then the same sorts of defence or measures for exemption could be established in court by the person who's been charged. I think that's how it would work in practical terms.
If I could add to that, you might have seen in the Bar Association submission that the suggestion is made, or there is some encouragement that there is consistency with the current subsection 5 defence. In the subsection 5 defence, there is an important reference to it being a defence that's proved to the court's satisfaction. So in those circumstances, as Mr Cowdery has set out, if the police are not accepting of the evidence prior to the matter proceeding to court, it is entirely within the court's purview or discretion to accept or reject the evidence, to accept or reject the defence, and also it can be subject to challenge by police or the prosecution in that environment. So there are checks and balances. It's not simply the raising of the defence and that's the end of it. That has to be within the court's satisfaction.
But the bill in its current form doesn't take it far enough there, does it?
At the moment, and this has been set out in our written submissions, at the moment there is perhaps some need for some clarification about precisely how that might work in practice in terms of the onus of proof, where the defence lies and who needs to prove what if it does proceed to court.
Thank you. That's all I have, Chair. Thanks.
I just want to as we're discussing the current exemption in relation to morphine, I wondered if you, and I think as the Young Lawyers submission also referred to sort of their preferred position being that this exemption would operate in the same way as that exemption. I wondered if you could just talk a little bit more about how it, you've set out how the law says that operates. How does it operate in reality? Have you had any experiences in relation to the operation of that exemption? Can you give us some more information in relation to how often do police accept that exemption when it's raised? How often does it proceed to court? How does that play out practically?
I don't know the precise statistics around how many matters proceed to court, how many are withdrawn in terms of the discretion of the police. I'm happy to take that as a question on notice and provide that information at a later stage in writing. In terms of the practicalities of how it would work, sort of the reality of day-to-day prosecutions, in a similar way to what was set out by Mr Cowdery, if a matter was to proceed by way of a penalty notice, then the person would have the opportunity to challenge that and raise that in court. If the matter was to proceed by way of a court attendance notice, to raise the defence prior to hearing, potentially by way of representations to police, and then at the hearing. Again, I can't precisely say how many have proceeded to a full hearing within the courts in terms of the current 115 subsection 5 defence. It may be that the Young Lawyers have some further information about that, but I'm happy to provide that.
That would be useful if you were able to take it on notice, but it's more, you know, what is your, if you have any, what are your reflections on whether that is successfully operating, you know, in terms of clients that you may have dealt with in your, I mean, I suppose perhaps it's self-evident that you think it's successful in a way because you've suggested that that be the way this exemption operate, but I am interested a little bit, you know, any reflections that people on this panel may have had about the actual use of that, whether they found it, them and their clients found it easy to use, whether it was something that was sort of very difficult or tricky to actually apply operationally, or whether actually it was relatively straightforward?
I don't have any personal experience in that particular, the operation of that particular subsection in a criminal matter, and I, of course, defer to anybody else in the session today who has had a personal experience. And again, happy to take the matter on notice if there's anyone from the Bar Association who can reflect upon the difficulties or otherwise of navigating that. I apologise that I can't be of any further assistance on the practicalities of that, but there might be somebody else who's able to comment on that.
Has anyone else on the panel had any experience with the actual application of the current exemption in relation to morphine that they're able to offer?
Unfortunately, I can't offer any personal experience. I can't speak for my young lawyers colleague though.
I think we would have to take that on notice to see if perhaps the rest of the subcommittee had further anecdotal evidence.
Oh, yes, you go, Lou.
That's right. Just following up, actually, probably from where Rose was saying earlier. So what's the difference between whether you get a penalty notice or whether you get a court attendance? So I understand if you get a penalty notice, well, you don't have a criminal record, but if you have to go to court and you get found guilty, then you will have a criminal record. Is that my understanding of it? And why would somebody get it, a penalty? Can you explain that?
In terms of the proceeding by way of a penalty notice and by way of a court attendance notice, I think that question is best answered by police, as I understand it to be a matter within the discretion of the police as to whether a matter proceeds by one way or the other. And that's not a discretion where, as I understand it, that discretion needs to be justified in one way or the other, at least not publicly. So perhaps that's a matter that's best answered by police. And in terms of the second part of your question, whether it results in a criminal record or not, that is, as I understand it, a relatively complicated definitional issue that arises from what one sees as a criminal record or as an entry on a criminal history that's not necessarily a criminal record. Again, happy to take that question on notice and place something in writing. The Bar Association has not reflected upon that in their current submission as to what the consequences might be and what that might mean. But that's as far as I can take it. I'm not sure if my colleague, Mr. Cowdery, is able to say.
They might know why you'd be given a penalty notice rather than a court appearance. Would any of your colleagues perhaps be able to answer that question?
Maybe not.
Perhaps not.
Some offences are able to be dealt with by way of penalty notice, so that you know, for example, a speeding ticket. You can pay the penalty on the penalty notice, which disposes of the matter without a criminal record in the sense of a criminal conviction. But if you don't accept the penalty notice, you then go to court and you find out on the merits of the case. And if you are convicted, the conviction is formally entered, well, then you end up with a formal criminal record from the court.
Yeah, no, I understand that, but I was trying to work out why the police would issue an infringement notice to someone and not to another person. I can understand it if they were driving in a manner dangerous or so forth, and obviously be a court attendance. But if it was related to the same issue and they just had THC in their system, why would one person just get a penalty notice rather than someone else have a court attendance?
Well, I think with respect, you'd have to take that up with the police, because it falls into, in part at least, the area of police exercise.
And we do have the New South Wales Police Assistant Commissioner at 3 o'clock. So you might be able to ask your question then, Lou, as well. Further, Ms. Fairman?
Thank you. Just following on from that question, I assume partly it has to do with which is outlined in the New South Wales Bar Association's submission, the cost of the penalty, which is prohibitive for many people, even if they were provided with that option, which is $2,200 for a first offence and $3,300 for a second offence, as well as licence disqualification of up to 6 months. Is that just to get that just confirmed, or else there, of course, is going to court. Is that correct? And I'm directing that to either Mr. Cowdery or... Do you know that?
Can I just make sure that I understand your question? Is your question does your question relate to whether someone might challenge the fine and go to court on the basis of the challenging of the fine?
Yeah, is it the situation that if, for example, they're pulled over and they have THC in their system and can the police say issue them with the fine of $2,200 and they might say, well, I can't afford that, well, you're going to have to go to court then. That's essentially the difference?
As I understand the operation of the legislation as it currently stands, that there is the opportunity for a person who has been issued a penalty notice to challenge the quantum of the penalty notice by electing to have the matter heard by a court, but it would be dealt with in a different way to the way that we're discussing today in terms of raising a defence and having a hearing.
Yes.
It would be generally where matters are challenged in terms of a fine that has been imposed. It is a much quicker and more efficient process through the courts. That's what I can say generally speaking about it, not specifically about this offence. I'm talking generally about road transport offences. I'm not sure if there's anything from Mr. Cowdery.
No, I agree. There are two lines of challenge from the initial step. One is, in effect, an appeal against conviction, if I can apply that loose term to it. The other is an appeal against penalty. If the only issue is the quantum of penalty, well then, as my colleague says, the proceedings
Thank you. Can I just maybe get your views? You have outlined it in all of your submissions, but I just thought it's worth expanding upon the fact that the current, essentially what we have before us is our current drug driving laws in New South Wales haven't actually kept pace with changes in other laws that have made medicinal cannabis legal, and why particularly, maybe starting with you, Mr. Cowdery, why that really needs to change? Why is that unjust?
Well, expressing my own personal view and not the view of the Bar Association, I think the whole drug driving law regime is misconceived. What we should be focusing our legislative attention on, if I may say so, is driving impairment. And these laws very largely miss that. Now, having created that problem, what this bill is now trying to do is to modify the effect of that strict provision by enabling people who are legitimately and for quite proper purposes ingesting THC to be exempted from the otherwise harsh conditions that have been imposed by the original legislation. So I think it's a small step in the right direction, but that's really the best that can be said for it. I just add, if I might, just add to that and give you an example of exactly what Mr. Cowdery is talking about. So this was sitting in a court in Hobart last year waiting for a matter, and a man was before the court, a drug driving charge. He's using cannabis but not on a scheme. He was using cannabis for pain relief, and so he's charged under Section 6A of the Tasmanian Act with driving with illicit drug, but could not avail himself of the exemption because it's not from a doctor. But he did have a letter from his doctor that said, "Been a patient of mine for a long time. He used to be addicted to oxys. He's now finally beaten that addiction. He uses cannabis, and it whilst I can't support that because it's working, he's now got a job again, etc. And I remember the magistrate just shaking her head, saying, "This is where the drug laws are so wrong. There was nothing untoward about his driving." So all that the Tasmanian law does is in a limited way exactly what Mr. Cameron's done. It's to mollify the impact. But there are still many, many people out there who are caught by what is an unjust law because it doesn't, unlike drink driving, it's focused on impairment.
Perhaps following Mr. Barnes, if that's okay, it makes a good segue to the young lawyer's submission. I mean, the Therapeutic Goods Administration now is offering guidance on the use of medicinal cannabis for epilepsy, MS, non-chronic cancer pain, people that are experiencing nausea as a result of chemo or vomiting because of their cancer, and palliative care. Speaking, I guess, anecdotally, I'm sure we all know at least someone that's experienced one of those conditions, and the law, as it stands, there's a chance that people who are using medicinal cannabis for those very just reasons could be sort of unjustly captured. Our submission, we also turned our mind to people that may be suffering from those health conditions and be prescribed medicinal cannabis, and then also live in a rural or remote area, because the burden of that conviction will be heavier on them. If they're to lose their licence or their ability to drive, they're going to be far more isolated than if the same thing happened to someone living in sort of an urban or a city area. So it becomes more onerous for these people.
Just following up my last one, just following up from that actually, is, so therefore, what are the, if you could just talk to the impacts on our court system and justice system of having THC listed under Schedule 111 of the Road Transport Act. Like, how much is it? It sounds like there are, all these cases going before the courts that really should not be and would free up our judicial system. We'd maybe start with you, Ms. Ferrugia, if you're already there. Ferrugia, sorry.
I can't speak to exact sort of numbers and percentages of how much this would free up our court system. That's something I have to take on notice. But I guess, as Mr. Barnes said, in that case that he experienced, there was clearly someone there taking up the court's sort of time and costing everyone sort of money and time that didn't need to be there. I can't speak to the numbers of people that are coming and taking up the court's time, but it'd be good if there weren't.
Could I add to that? There is a gentleman by the name of David Hyper, magistrate who sat as a magistrate at Lismore for many years. There's a whole series of judgments that he issued in that time in relation to the presence of THC driving cases that he dealt with. The committee would be well advised to get hold of that bunch of judgments and have a look through and see the problems and the scope of the trauma and trouble and expense.
Yes, thank you. He actually was coming to, he was invited to appear today, but unfortunately he had to be in court and couldn't, but we will endeavour to do that, maybe.
Absolutely. Mr. Donnelly.
Thank you. And thank you all for making yourself available this afternoon. The matter of impairments that we've just made some comment on or some reflections on, been put before us in some of the evidence today and in some other submissions about understanding impairment in the context of being inebriated with alcohol. And we have obviously a law around an amount which is deemed to be an impairing amount, and we know what the consequences are for driving on or above that limit. But with respect to the matter of illicit substances, and if we use the case here, not making distinguishing between medical and non-medical cannabis, but just on the matter of cannabis in general, the issue of of understanding accurately the matter of impairment is much more difficult. So just invite witnesses to just pass some comments about the issue of trying to understand the matter of impairment and how that's able to be dealt with a substance which is unlike alcohol, where there is a community acceptance around a limit relating to impairment.
Yeah, I might. We've done some work on this, and I've done work more broadly on it, so I might very briefly.
Thank you.
There is some work being done on this, Mr. Donnelly. I think I'm right in saying in Canada, in the United States, where of course cannabis is legal in a large number of states now, and of course it's now legal in Canada across the nation. There is work being done on impairment levels because, of course, in relation to drink driving, those laws came about as a result of a vast number of epidemiological studies which established scientific way an impairment level. There is work being done, and I think in the UK, I'm not across the work, but there's certainly quite a lot of work being done, and there's a man called Michael White, I think formerly Adelaide University, now an emeritus professor, I think, who is very well versed in this area and might be worth the committee contact.
They provided, in fact, some evidence earlier today, which was, yeah. No, thank you. I mean, it's quite opposite, yeah.
Yeah.
If I could make a comment about that. The law cannot deal with absolutes, generally speaking, the criminal law. And what has been done with alcohol is to find a level that is acceptable to the community to be enforced. So, I mean, almost any mind-altering likely, and I'm not a medico, but is likely to create some kind of impairment in the motor functions, the mind-hand coordination, etc., functions that we do, including in driving. So it's a question of drawing a line with what is going to be an acceptable limit. Now, medical evidence can probably give you this information, but the vice of the present drug driving law is that it doesn't try to draw any comfort line. It just says that if you have any presence at all, then in brackets you are deemed to be impaired, close brackets, and you have committed a criminal offence. And there's just no logic, there's no reason, there's no rational basis for that.
But can I just perhaps be the devil's advocate and say, if we take that proposition as being a reasonable one, do you understand why legislators just might be a bit reserved if there is no consensus about an amount that goes to the question of impairment, moving from the current legislative provision?
Well, I would suggest that a consensus can be built by the evidence being broadcast and by appropriate consultation and debate about the issue. It's done with alcohol, as Greg Barnes has said. It can be done with other things as well. This really comes down to being a matter of balance. You won't get absolutes enshrined in legislation. You have to balance competing interests all the time. Strike the right balance that is going to be acceptable to the community and effective in keeping the community safe.
If I can add to that comment as well, within our submission, we commented on the difference between Section 111 and Section 112, and we've advised consideration around whether or not this would impact Section 112, and we've also advised that to the extent that it can be drafted such that it doesn't, that is ameliorated to some extent. Further, we've also provided submission on the recommendation that we not get into the weeds of implementing further restrictions on this very limited scope exemption on the basis of time limit or waiting period, simply because of this matter where we don't have the sort of general consensus on affectation.
We'll have time for one last question, if there are any.
Look, I might ask a question, although I'm not sure, considering most of the panellists are from the kind of criminal law division, will necessarily be able to add anything. But I did want to just ask, the New South Wales government in its submission to this inquiry drew attention to what it claimed were possible insurance implications for this change, in that previously ineligible at-fault drivers, because they are currently ineligible for CTP statutory benefits because they're in breach of the law, would become eligible potentially through the operation of this exemption, and this may have some impact on insurance premiums. I just wondered if anyone were able to reflect on that. As I said, I think perhaps not, because I know most of you are criminal lawyers, but there hasn't really been anyone else on any of the panels who might be able to reflect on that. So I thought I'd just ask if anyone did have any experience in relation to insurance law and the way that that might work.
I don't, but what I can say is that in Tasmania, where this provision is now being I've never seen an article in the media. I'm not aware of any increase in.
That's useful. Thank you, Mr. Barnes.
Great, thank you. Thank you to all the witnesses for attending and for your evidence today. The committee has resolved that answers to questions taken on notice be returned within 21 days. So the Secretariat will contact you in relation to the questions you have taken on notice. As well, committee members may have additional questions that they may that we may put to you. So thank you for coming today.
Thank you very much.
Thank you. Thank you.
We'll just stay on air and get the next lot of witnesses as well.
Organisation. Oh, she's on teleconference. Yeah.
Good to see you. It's good to see you too.
Where's the seat?
That's okay. In your way.
Thank you.
Right, we're all settled.
Can you hear me? This is Marion from the Secretariat.
Brigitte as well. Brigitte,
can you hear the Secretariat now? Can you hear me speaking?
We might get started with the other witnesses. So I will now welcome our next witnesses. Could each witness please state their name and position title and swear either an oath or affirmation. We will start with Mr. Carlin.
Bernard Carlin, the Chief of the Centres for Road Safety and Maritime Safety at Transport for New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Great, thank you. Mr. Dunphy?
Yeah, Peter Dunphy, Head of Transport Safety, Security and Emergency Management for Transport for New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Mr. McFadden.
Yes, my name is Brett McFadden. I'm an Assistant Commissioner. I'm the Commander of the Traffic and Highway Patrol Command for the New South Wales Police Force. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Professor Martin.
I'm Jennifer Martin. I'm a physician and a clinical pharmacologist. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Associate Professor Mernion, can you hear us?
Yes, I can, thank you. Can you hear me?
Yes, we can. Would you like to state your name and position title and swear either an oath or an affirmation?
Of course, I'm Associate Professor a clinical pharmacologist, addiction physician and pain physician, working or representing New South Wales Health. I solemnly, sincerely and truly declare that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Great, thank you. And since we're on with you now, Associate Professor, did you want to make an opening statement?
I don't have an opening statement.
That's okay.
Sorry, my understanding was that it was to come that transport were to do the opening statement.
Just the one?
It's just the one statement.
Okay, sure. We'll go to you then. Thank you.
Thank you and good afternoon. I'm here from Transport for New South Wales with my colleagues from New South Wales Health and New South Wales Police Force to answer any questions the committee has about the New South Wales Government submission. I'd like to start by briefly explaining relevant road safety offences. There's a two-tiered approach to drug driving. There's one offence for driving under the influence, which is the DUI offence. This offence applies to a driver who, when stopped by police, is visibly affected by a drug and has higher penalties equivalent to the higher range drink driving. The one we're talking about today is the other offence to which the bill applies, is for driving with the presence of one of 4 prescribed drugs, including THC. As roadside drug testing can be undertaken anywhere, anytime, it is designed to deter drivers who have recently used illicit drugs for driving. We've seen how successful this has been for random breath testing, which commenced in 1982. In 1980, 389 people were killed in alcohol-related crashes in New South Wales, compared to 51 in 2020. But this change in public attitude does take time. Crash data in New South Wales shows that between 2016 and 2020, there were 253 fatal crashes involving drivers and riders with the presence of THC. This represents 16% of all fatal crashes and approximates closely to one fatality every week. THC can affect cognitive and motor skills necessary for safe driving, such as attention, judgment, memory, vision, and coordination. Medicinal cannabis patients are advised they should not drive while using the product that contains THC. Of course, CBD-only medicines would not be detected under roadside drug testing, and patients taking CBD-only medicines can lawfully drive as long as they are not impaired. While it is true that much of the evidence for impairment impacts are from illicit THC use, there is still evidence that medicinal cannabis users can be impaired for a period of time. This can significantly due to differences in this can vary significantly due to differences in ingestion method, dosage, presence of other drugs or medicines, and individual biology. It is therefore not possible to be certain of the effect of any dose of medicinal cannabis on an individual. Medicinal cannabis is not comparable to other drugs due to the large-scale use of recreational cannabis and the inability to distinguish between medicinal cannabis from recreational cannabis when analysing samples for our roadside testing. I heard the evidence this morning and throughout the day. I know there are many people who would like to see the bill passed. As part of the 2026 Road Safety Action Plan, the New South Wales Government has committed to continuing monitoring drug driving research and developments. Until there is clear evidence on the effects of medicinal cannabis on driving, the New South Wales Government will continue to take a cautious approach to changing policies and consider the safety of all road users. I must also highlight the practical challenges and implications of this bill, which I think have been discussed this morning. Firstly, there is no reliable way to distinguish at the roadside whether the source of THC detected is illicit or prescribed as medicinal, or whether the driver has used cannabis illicitly in addition to their prescription. Secondly, to attempt to determine whether THC from cannabis was administered as prescribed by a doctor would require a blood sample to be taken by an authorised sample taker and would require expert pharmacology review. This is a much more invasive, uncertain and resource-intensive process for everyone involved. It would limit the ability to deliver the high volumes of roadside drug tests that serve to deter drug driving, an approach that has community support and has been independently evaluated in Victoria as successful in saving lives. Alternatively, if we were to rely simply on a medical exemption certificate without actual verification, there is no way of knowing if the patient had taken the product as prescribed and without any other additional substances. This is just not workable and is contrary to the wording of the bill and is too much of a risk for other road users. A similar bill was introduced in Victoria in 2019. An expert working group was established to look at the risk of medicinal cannabis and options to implement the bill that would not be detrimental to road safety and would ensure the integrity of their roadside drug testing program. In 2021, the group produced a final report with no consensus and did not recommend progressing the bill. But finally, at this stage, in the face of the existing evidence and the practicalities involved, New South Wales Government is not ready to allow an exemption for THC medicinal cannabis users. I'll stop there.
Great, thank you. And we'll now hand over to committee members for questions.
I obviously have questions.
Ms. Fairman.
Thank you, Chair. Thank you for making a submission and for your opening statement. I just wanted to go to some of the data that you have raised in both. So you have raised the success of the roadside breath testing scheme, random breath testing scheme in your submission, and you said that it had seen alcohol-related fatalities drop from 389 people in 1980 to 51 in 2020. So is there similar data to suggest the same success in the mobile drug testing scheme?
We've seen across the board in terms of reductions through the road safety programs. We've seen significant reductions in road fatalities over a period of time, from the early 20s down to last year. We had the lowest level of road fatalities in almost 100 years. So the general trend in all of the areas have certainly shown those decreases. But I might just. But
that's specifically you quoted with the roadside drug testing, the random breath testing scheme, that was specifically in relation to alcohol-related fatalities. The success has been said, dropped from 389 to 51. So specifically in, let's say, THC-related fatalities, have you got the same data?
We do have data in terms of the reduction in fatalities for drug offences, and I might just refer to my colleague, Mr. Carlon, to provide a little bit further information about that.
Yeah, so in relation about the overall data, it indicates that there has been a decline, but it's not significant. We can provide the data to the committee. I think the key issue here in comparison with the roadside breath testing program and the 50 years of research and implementation of strategies for reducing drink driving related fatalities and serious injuries over those many decades is that general deterrent approach that's being used in terms of RBT and the specific deterrent approach, and then of course the penalty regime which has been put in place, and then the changes over time that have been implemented as well, right through to the graduated licensing system where provisional drivers are actually now required to have 0 BAC when they can drive a vehicle. Similarly, this program has only been in place for a fifth of the time in terms of the reduction and the implementation. We have seen a significant increase.
How many years is that? Sorry, a fifth? When you say fifth, how many years?
Oh, about it's more than a decade. Yeah. Yep. And we have seen a significant change in the demographics and the use of drugs throughout the community, and increased over time from 30,000 tests in terms of the mobile drug testing program to 100,000 tests to now 200,000 random tests.
So I suppose with all of that, I'm just trying to get to the sense, you've got, say, up to 200,000 tests, and you've also got, you also say in your submission where you suggest that in numerical terms, this means that of the 264 fatal crashes in New South Wales in 2020, THC was a factor in nearly 60 deaths. How was that determined? How did you determine that THC was a factor in those 60 deaths?
Yeah, so that's the presence of THC in the driver's blood and the controller's blood.
So the presence of THC in the driver's blood makes you draw the conclusion that THC was a factor in nearly 60 deaths. Are you serious? You can't be serious.
So we know that THC has an impairment.
Did you draw that
Presumably
conclusion?
a bunch of them were women. Maybe that was a factor in their death.
Did you?
Order. We'll have this in question-answer format, Ms. Behrman.
I'm just wondering, did the government draw that conclusion, or is that like peer-reviewed research that has found that THC was a factor, like caused a factor in nearly 60 deaths?
Yes,
or do you mean it was just present in their system?
So we know in our research, and it might be useful actually to refer to Professor Martin on this as well, about the impact in terms of THC in the blood.
I was just going to clarify the difference between being a factor and the cause. And we have this problem in medicine all the time where it's often done on probabilities and the whole environment, because often people that have got THC are often taking other medicines as well. So often it can be difficult to be certain what has done what. So there is a difference between being 100% sure on causality as opposed to being a factor that is known to contribute to people's impairment, which is known to contribute to death.
Professor Martin, do you have the rough statistics in your head in terms of how many people in New South Wales any given day are taking cannabis, using it either medicinally or for recreational purposes?
I'll give you those numbers in just a minute, but it reminded me to also add to that point of when you're talking about the reduction in deaths from THC, that we all have to remember that these drugs are a lot more available in 2022 and going forward than they were in 2020, and we can see that from the TGA data, which shows just the number of prescriptions, so those that have gone through the SASB. So I think if we're looking at a reduction in numbers with THC, we actually also have to be aware that there's so much more availability and use in the community. In terms of the numbers, I will, I've got it in my notes, so I'll get back to you in 1 minute. I might hand over to my colleague, Professor Brigitte Murnian, who may have the numbers at her fingertips. Do you have those, Brigitte? The numbers for New South Wales.
I have the
TGA do?
The national statistics on recreational cannabis use are that it varies obviously in different age groups, but the 2019 National Drug Strategy Household Survey indicated that 25% of people between the ages of 20 and 29 have used recreational cannabis in the year. Those are the statistics on the use of time to identify those in your papers yet?
No, I'll take that on notice, but we've got those numbers.
I might be able to add that in the government submission, we did actually refer to the number of the percentage of users of cannabis in the community. I think it was 12% of Victorians detected in autopsies or road deaths. THC is used recreationally by a large number of Victorians compared to other recreational drug users. I think what we identified in New South Wales, the figures cited similar for New South Wales, and it was 11.4% of people in New South Wales aged over 18.
Thank you, and you're aware.
Illegally.
Thank you that is in your submission, and you're aware that quite a few of those people who, well, everybody actually who uses cannabis will have traces of THC in their system, kind of in sometimes hours, if not days, beyond when in any way they're impaired by that drug. I'll ask you, Mr. Dunphy. You're aware of that?
In terms of just getting back to the point that you raised before about the behavioural factors, we do from the Centre for Road Safety.
But it's just a question about impairment or tracing. I'm not asking about impairment. It's a question. You are aware that traces of THC can stay in a person's system well beyond when they are impaired.
So if I could just address the oral fluid sampling that was done at the roadside, and I might then hand to Assistant Commissioner McFadden as well. But essentially, the device that we're using for oral fluid swipe in order to screen drivers on the side of the road does not detect traces of illicit drugs, in particular THC. It only detects recent use, and I'm also happy for our colleagues from Health to talk about the time frame in which oral fluid THC is detectable.
You are aware, Mr. Carlin, that we received contradictory evidence on that basis from the experts at the Lambert Institute this morning. We asked them exactly that same question, and they said it wasn't fair to say that oral swabbing only detects recent use. They just said that is not a statement that they felt comfortable making based on their expert research.
But Professor Martin might have.
Well, hopefully they can provide that evidence. I mean, it is correct that you can pick up in the blood fluid and the urine the parent drug of the THC and the metabolites for a number of days, in urine 14 days, maybe even longer, after someone's ingested some THC. So in terms of the oral fluid, it's very unusual for chemicals in the blood to end up in the saliva, this particular drug. It's certainly possible, but there'll be very, very small amounts detected in the oral saliva if there was if it so happened that you had a high amount in the blood. So it's usually the other way around.
I just wanted to, thanks, just a couple more questions. I just wanted to clarify, so this submission, this was authored by Transport for New South Wales. Was the lead agency in relation to the submission?
The government submission that was coordinated by Transport for New South Wales.
And so New South Wales Health, you were consulted and approved this submission?
Yes, I didn't see the submission, but the evidence that I've given is from a pharmacological perspective about drugs moving from the blood into the oral
Of course,
fluid.
sorry, I was referring in general, not the evidence that you just provided. This written submission was, New South Wales Health was consulted on and approved this submission?
I didn't see that submission, but before it was submitted, I have read it in preparation for giving my evidence today.
And it is a whole of government submission, yeah.
Oh, yeah, obviously I'm aware
New
of
South
that.
Wales Health Police were consulted, yes.
Yeah. My next question was, one of the things that you referred to, Mr. Dunphy, was the paucity of evidence in a way in relation to the impact of medicinal cannabis on driving. The issue being medicinal cannabis users are regular users who are not looking to get high. They are looking to relieve pain or other symptoms, nausea, vomiting, seizures, whatever it is. Again, the Lambert Institute suggested that they would be very enthusiastic to partner with government on a study that looked specifically at that issue. Is that something that you are open to, that the government is open to as potentially a way to move forward on this?
Yeah, no, absolutely. We, in the 2026 Road Safety Action Plan, certainly one of the priorities and one of the areas that we focus on is really looking at further research. We recognise that, we want to be best practice. We want to make sure that whatever our control frameworks have, whatever advice we're giving in terms of road safety is world's best practice, and we can only do that through really supporting through good evidence base. We're very strongly supportive of the research. I think, as everybody has discussed today, there is still gaps in the research, and we would certainly appreciate and welcome further research in this area to better understand the impacts and also to better target our approaches in terms of prevention and also the enforcement approaches.
One of the issues that has been consistently raised is the different treatment of medicinally prescribed cannabis to other medicinally prescribed legal drugs, opiates and benzodiazepines specifically. I mean, can you give us your explanation as to why it is fair that someone who perhaps has transitioned from being addicted to OxyContin or other benzodiazepines, which is, I'm sure health would agree, an extremely problematic position for someone to be in, has moved away from those kind of addictions to medicinal cannabis use, legally prescribed by their doctor. They are open to losing their licence because they have moved away from taking prescription benzos or opiates to taking prescription marijuana. And in fact, we have heard evidence that people are avoiding that transition and remaining on drugs that they don't want to be on. It's making them feel like zombies because of the driving prohibition in relation to THC. Can you explain why you think that distinction is fair?
Yeah, well, look, firstly, we don't discriminate against any prescription drugs. The whole purpose of...
But you do discriminate against prescription THC. It is treated differently.
But in terms of, I guess, the approach that we take is we're not, our focus isn't on what's a prescription drug. Our focus is on ensuring road safety and ensuring that people who are driving are not impaired in terms of the activities that they're doing. In terms of...
but you know that people...
Can I comment on that?
Oh, sorry, yes, Professor Martin.
Would it be all right? In terms of the fairness, I'm not sure whether that's a discussion so much for us today because we're worried about patients and about impairment and harming others just from a health perspective. So the fairness is certainly, I can see it's an issue for others, but certainly on a daily basis, as a physician in the hospital, I will have to take people's licence off them or tell them they can't drive because they've had a stroke or they're impaired in some other way or there's a perception of impairment, so we're waiting for further testing. And I understand that that is not fair and it's certainly perceived as not fair by that patient or their family sometimes. So I think the fairness thing is slightly different to what we understand also from a health perspective. And I will say some words, and I wonder if we could just bring Brigitte in at that point, because I think there's a bit of a narrative around people having to take THC for a bit of pain here or taking THC for another indication. We need to remember that there's actually no evidence to support clinical use of any of the cannabinoids apart from in two small indications for cannabidiol, which is not the subject of today's discussion, for a rare form of paediatric seizure and for resistant multiple sclerosis. So the patients that are getting prescribed on a script are able to access a special scheme through the TGA, which is not as a registered drug. It hasn't got the safety or the quality or the evidence data to support its listing, but we're making it available for patients end of line as a trial. And because it's end of line, these people are very sick. They're often taking multiple medications. And therefore they often should not be driving anyway, and that's certainly the recommendation for many of our patients that do wish to take medical cannabis and drive, because they're already on a number of medications and the cannabis is end-of-line therapy for these patients. So I think the fairness I think it's an important thing to consider, but certainly from a safety to own patients' health and a quality practice for health. It's actually even unclear whether there's much support from the medical practitioners. I appreciate you've referred to the Lambert scientist twice, but from the medical practitioners generally, and from our registration process, there hasn't really been a lot of support for routine use of these compounds for the common medical conditions that you bring up, such as pain and insomnia. And I just wondered if it might be helpful for my colleague who works more in the addiction perspective. I work more in general medicine, for my colleague to discuss, if you're willing, about the patient group that we're talking about here that actually have access to THC and the fairness discussion.
Definitely.
I might maybe step back a bit, thank you, Jenny, and address perhaps one statement that was made by the committee, which was about the use of cannabis to treat opioid addiction or opioid dependence, which is probably what we would more call it. There's no, that is not a recognised or evidence-based or recommended within any New South Wales or Australian guideline. It's not a way to manage opioid dependence. Moreover, myself and colleagues from Turning Point Addiction Research Centre in Monash University, we've recently published our second review of whether or not cannabinoids have a role in opioid sparing. And it's clear that it is an analysis of both animal and human data that we don't have any human data supporting that. So that's very much early in early scientific really development. There's some animal data, but it's very specific animal data for very specific substances. So I think in terms of cannabinoids being used as management of opioid dependence or as opioid sparing, we don't have data to support that. In terms of the use of cannabinoids in chronic pain, the database supporting cannabinoids in chronic non-cancer pain, and I think we need to, when we talk about pain, differentiate between non-cancer pain and cancer pain. That's clinically what we do. We have different specialties dealing with both, and clearly there are different trajectories of both problems. Certainly, the majority of people using medicinal cannabis in Australia, I believe, are doing so for chronic non-cancer pain, and there's a paucity of data indicating benefit outside the situation of assisting-related multiple sclerosis. There's some early data that there may be benefit in other nerve pain-related conditions, but the data for the use of cannabinoids in chronic pain, specifically chronic low back pain and fibromyalgia, which are the commonest pains, is very, very unpersuasive. It really doesn't suggest a role there. So, and the best treatment that we would generally recommend for those conditions are exercise, weight loss, and psychological interventions. We would also generally be steering away from long-term opioid use in that situation.
The inquiries about that.
Increasingly. So, does that...
it's legal.
Well, it does, although I want to be clear, I didn't just make up those comments that I made in relation to people using cannabis and THC products to try and resolve their opioid dependence. Not as though I just made that up. That was evidence that we have in fact received from multiple witnesses to this committee. So I just want to be clear on that.
Yeah, we just provide the evidence.
I certainly appreciate that, but my recent meta-analysis and systematic review was published in Neuropsychopharmacology from but about 2 months ago actually shows that we have no robust data in humans that cannabinoids are sparing, in the sense that they have people reduce their opioid dose.
I've got a couple of questions just going back to the statistics that we're talking about before in terms of motor accidents that are related to cannabis use. So isn't it the case, though, that it would be impossible or indeed very difficult to separate the motor accidents that are caused by cannabis impairment versus those that would just be as a result of people with a THC presence in their system? Like, you couldn't, I assume you don't differentiate, and I would assume you don't because it would be very difficult, near impossible to differentiate.
I think, and there has been evidence earlier today around, I think there's binary discussion around the contributing factors to crashes. And, you know, we do talk quite often around the speeding issue or the drink drive issue or the illicit drug issue. And, you know, the reality of crashes is that they are multifactorial, that there are a range of factors which come to bear. And in these 259 drivers and motorcycle riders with the presence of cannabis in those 253 fatal crashes, 24% also had illegal alcohol recorded, 13% also had fatigue recorded, 55% of them had speeding recorded, and we do know in the analysis of those crashes where people actually have consumed cannabis that in fact they're higher, more likely to involve alcohol, and they're more likely to involve speeding because those behavioural factors are actually associated with that risk-taking behaviour. And so I think like it is important to understand that, and the road environment, and I know that Michael Timms raised this morning, the vehicle safety features, the road environment, there's a whole range of factors which cause the person who's in a crash to either die or be seriously injured. And certainly the evidence, there is, I think, agreement universally in the evidence that THC has an impairing effect on the ability to safely drive a vehicle. When combined with alcohol at any level, it actually is 40 times more likely to cause a crash involving serious injury or fatality. And so it is, that is the rationale for having a general deterrent program and oral fluid and large-scale implementation of the detection of the presence of those drugs from recent use through an oral fluid system.
Yes, so I suppose it's more accurately expressed would be THC-related motor accidents rather than THC-caused motor accidents because of the multifactorial nature of what you're talking about.
So I think that we describe it as, it is present in the drivers and riders who were involved in or in control of those vehicles who were involved in the fatal crash, as were the speeding behaviours or a whole range of other factors as well.
Yes.
But the evidence, I think, in the same way for drink driving, that for the last decade we've been telling people to, if you're going to drink, don't drive, because every drink you have has some impact.
Yeah.
And we have set a legal framework around 0.05 for the general population, but we've set 0 for provisional drivers. In this instance, for these 4 illicit drugs, we've set a I suppose a zero tolerance approach to the presence of those drugs in an oral fluid screening program, which then gets validated by a secondary oral fluid sample being tested at a laboratory.
I think it is important to measure those statistics because, you might not be able to prove that with 100% certainty that those accidents were caused by THC, but nor could you prove with 100% certainty that it was definitely not as a result of the THC. So if you stop measuring that entirely, which may be a suggestion, then you wouldn't accurately be capturing that at all.
Yes, I think the key is, and when we look to the review of legislation proposed in Victoria, is the need for more additional research about the impact from a risk perspective, a road safety risk perspective in relation to medicinal cannabis. You know, that there are gaps in our knowledge and there are different positions being put by different stakeholder groups as well.
I think,
sorry. Yep.
Just if I could add to that too. In terms of the way that we do report, we report on the behavioural factors. So we know that certain behavioural factors can have an impact in terms of road crashes. You're right, the causative links are not always, you can't prove or disprove those, but what we do is try to unpack the data as much as we can and to be able to identify those behavioural factors we know are, can impact road fatalities and report on those across those.
But sometimes it's very hard to prove causation. It could just be very highly correlated rather than actually proving the causation on any accident.
That's right. But from a safety perspective, you want to unpack as much as you can the information you've got around that particular incident, and that's helpful in terms of doing those safety assessments to see whether there's anything more that can be done to prevent those fatalities.
Thank you.
And I suppose I just clarify, there are, and there is significant body of evidence over the last 50 years in the road safety research and evidence that there are very specific results of particular behavioural factors causing crashes, and there are very specific factors causing the level of either serious injury or death associated with the environment those crashes happen within.
Mr. Donnelly.
Thank you. Thank you all for coming along this afternoon, participating. Just wondering if any of the witnesses have some insights into what happened in Victoria with the study they did down there and the consideration of the whole matter. Obviously, it's referred to on page 8 of the submission, but does anyone have any particular knowledge of how it played out in Victoria? And obviously, it was a contested area and it ended up in the way that it did. So can anyone that's got some insights into Victoria able to comment?
Yeah, probably can't really comment on other jurisdictions' deliberations and how they landed on their outcomes. Generally, I guess we can say that, as I think you've experienced today, there is a lot of different divergent views in terms of, and the research is incomplete. There is more research that needs to be done, I think, to further quantify issues. I guess we are working from a precautionary principle based on what we know around the evidence. I guess in terms of what behavioural factors are important in road crashes, and we do want to make sure that the work that we're doing is continuing to drive down that the road fatality rate. I think, and happy for my colleague Mr. Cullen to add to this, but I think it was very difficult to be able to rule out the knowledge of impairment and how much that translates to the road toll and to potential injuries and serious injuries and fatalities.
Which brings me to my so thank you for that. On the same page, page 8 of the submission, just take you to it. It's actually the final paragraph on page 8. Just the first sentence. It says, laboratory tests and research studies show that the effects of THC on individuals vary more than with alcohol. Now, is that part of the concern that with respect to THC, there is a wider spectrum or a broader scope of understanding its impact on individuals compared to that of the consumption of alcohol. And
I might ask my colleague, Professor Mudden, to talk to that, but I guess with alcohol, it is something that is very clearly labelled in terms of the alcohol content, in terms of consumption and use, and has been more widely researched in terms of the intoxication levels and the impact. But I'll hand over to my colleague.
Oh, thank you. I think that it's a good point, and it comes back to the earlier point that I made, that the people that that there's evidence that you should prescribe or give them a trial of medicinal cannabis are people who are at the end of line of treatment, because these drugs are not registered apart from the two I mentioned. So these are off-label indications for people for whom there's no other options, and people are wanting to know whether this chemical might help them. So they are usually people with cancer or at the end of life. They're people on with other chronic diseases that have symptoms that distress them. And these people vary depending on what disease or underlying condition they've got in terms of the amount of body fat even. Now, if you're a big person with a lot of body fat, you can store a lot of THC in that body fat that can leach out over time. If you're a thin, hectic person at the end of life, you might get much more brain impairment from the same dose because you haven't really got a huge amount of distribution in the fat tissue. So that means that, and what we're finding in the clinical trials which we're running, is that there's a significant variation in dose and the levels that we're getting. But in addition, that relationship between the levels in the blood and impairment in terms of how patients describe their sedation or their brain fogginess or their cognitive dysfunction, that can vary significantly as well. And it's so variable, it's actually become quite difficult for us as clinicians to predict how someone's going to respond. So we usually start low, go slow. But just in relation to that, because these people are often on antidepressants, other pain medicines, they're frail, they've got other diseases, they're already not driving. But I think just that concern about the variability, because we can't predict whether someone's impaired or not, that we tell people not to drive if they're coming onto the clinical trial program or if they're being prescribed it.
Just one final quick one. The issue of impairment obviously has featured a great deal over the course of today.
Yeah.
And I've asked this question before, but I'll boil it up again. About clarity around what impairment means. You've just referred to, obviously, discussions between a clinician and a patient and receiving feedback or comment from the patient and helping to elucidate the person's impairment or otherwise. But how else is impairment understood?
Well, I can talk from a medical perspective. My colleague might want to add in as well. I mean, it's a complex picture. There's no clean definition, but it usually involves a cognitive and or a psychological and or a physical and or other features of impairment, which are usually measured, well, they are measured objectively, because it's very difficult when you're impaired to know you're impaired, just as if you're impaired because of a mental health issue. So it sort of speaks to our whole discussion around impairment, ability to consent for treatment. It's a very big discussion in the medico-legal area, but traditionally, well, impairment is not usually how good you feel. So a patient might say to you, I drink this much, but actually I'm not impaired. And that's why we have these objective tests to actually tell how impaired somebody is. But certainly from the cannabinoid perspective, depending on which cannabinoid you take, what other drugs you're taking, what your disease is, what your body shape is, your impairment may be more cognitive than physical, or more psychological than physical. And that's why it's such a complicated area, and people feel that it's so complicated that you can't be sure that a number or a cut-off figure in the blood would ensure comfort that you know that person is or isn't impaired.
Associate Professor, I think you've got your hand up. Yeah.
Thank you, and I'm so sorry somebody has decided to drill a hole outside my window. So a comment on assessing impairment. When we look at people who are using alcohol, they self-rate their impairment much lower than we do when we formally assess their impairment. So an individual's perception of impairment is much poorer than the objective analysis. Drug-related impairment clinically for us in the clinic, it can range from seeing someone, as I'm sure we've all seen them on the street on a Friday night, barely being able to stand up. And we know they're very clearly, very lots of very subtle assessments of your cognitive assessments and executive decision making, which are quite critical, which are complex tasks such as or writing a will, or planning your day, or going shopping. So it can be a very complex process of assessment. And it's certainly people underrate, with alcohol, they underrate the
I think it's useful as well, and we refer to the Victorian paper that was produced by the committee reviewing the legislation, and there's evidence on THC and road safety risk that shows that there's a global consensus that THC impairs key driving skills, and that this is supported by a host of psychometric, behavioural and on-road studies that have been published. In the document published by Victoria, there's actually an appendices of all of those research studies that actually demonstrate that THC causes risky driving behaviours such as lane weaving, inappropriate speed changes, following distance reduction of reaction times, reduced capacity to divide attention and reduce vigilance. So there is a body of evidence that's been published over time in relation to recreational cannabis use. And I think that the clear issue was that there is no significant body of evidence in the same vein with regard to the medicinal cannabis currently, because this body of evidence has been gathered over a significant period of time, and a lot of this new evidence for medicinal cannabis is emerging.
Mr. Amato, I think you have a question to the Assistant Commissioner.
Yes, thank you, Chair. Welcome, everyone. Assistant Commissioner, I actually asked this question earlier on to the Bar Association. They said it was a police discretion matter. So it was in relation to why would a person that's come up positive for THC, why would one person be given a penalty notice and someone else be given a notice to attend court?
Okay, I think it's probably just helpful to understand the process generally. So I think it's from about 2018, some new measures where penalty notices were introduced to assist in streamlining the process, least invasive detaining of people. So there's an option for a penalty notice to be issued for a first offence for a positive indication of THC. The penalty is about $587, I think it is, which is consistent with a load range PCA infringement notice.
And so that's 6 months loss of licence as well, isn't it?
I'll take that on notice, but I'll in terms of the penalty and the regime and where it sits compared to, say, an alcohol, just for our understanding. However, that's only for a first offence, so if there's subsequent offences, that option's no longer available. However, on the first occasion, it's the environment, appreciation of the circumstances in which that offence is identified. So, for example, it may be the first offence for a roadside drug test, but the particular individual may have an extensive traffic record, he may be a disqualified driver, may be subject to bail conditions for a whole range of other things. There may be factors in the investigation, the wider investigation, that actually involve, there might be a domestic violence matter in play, there may be other things that come to the fore. Yeah, and they're the things that, you know, that original authority of discretion is designed for, to say, well, let's look at the person, the circumstances in which we find them, to give us options that are available to us. And for the safety of the individual or others concerned, it may be more appropriate that a court attendance notice is the appropriate mechanism to act on this particular offence, because it's tied up with other matters, or there's antecedents that need to be considered, or the wider safety of the community. And so it's just merely a process of how it's looked at. I hope that assists.
Yeah, thank you for clarifying that. And in terms of criminal record, if you just get a penalty notice, do you get a criminal record?
Okay, so if you receive a penalty notice and that notice is paid, there's no criminal record really associated with that. If you choose to take the matter to court, that act of, but it certainly there's provision by magistrates to have a no conviction recorded. It merely you enter the justice system to have that sort of work through, and it may be that at the end an outcome by a magistrate is that I'm satisfied or not satisfied. If they're satisfied, the provision of no conviction can be available, so it doesn't impede anything in the future.
Is that subsequent times as well, just for clarity, the no conviction, or magistrates needing to, if a person comes before the court for a second or third time?
So if an infringement notice is given on the first instance, and just so that's resolved in its own way, if they the same individual experiences a second detection, there's no option to actually give an infringement notice that goes to court. But you can't have a conviction recorded to you unless you've got a previous conviction at court. So there's it's an escalating cycle of, there's options for an infringement notice, there's options to take the matter to court on the first occasion. So really, in a pure instance, it wouldn't be to a third occasion that an individual would be susceptible to a conviction.
Can I just ask a quick follow-up question, just in relation to, you may have to take this on notice, in relation to a first offence only, whether a penalty notice is issued or a court attendance notice is issued, how that is different for THC, methamphetamine, ecstasy and cocaine? Do you have that information?
I can make some inquiries and get back to you before we close today. I'll seek my assistance in the back.
Potentially you can take it on notice. I'm just interested about the percentages in relation to each of those different categories, where a penalty notice is issued for a first offence or where a court attendance notice is issued.
Okay, I'll take the question on notice, but in terms of some numbers that may assist generally, for our penalty notices, bear with me for a second.
Ms Fairman might ask another question while you're looking.
We've just got 5 minutes left. So while you're looking, I just wanted to just get some clarity from the New South Wales health witnesses. So maybe with you, Associate Professor Murnion, you were talking about the two legally where is it? The
registered products?
Yes, the registered, the ones that are through the ARTG. Can I just get clarity then? Is New South Wales Health trying to suggest that medicinal cannabis available through the special access scheme isn't as legal, if you like, or doesn't have as much standing as that available through the ARTG?
Is it to me or to?
Professor Martin, we can start with you if you like.
I'll steal your thunder, Brittany. The products are either registered on the ARTG or there are provisional pathways. I shouldn't use the word provisional, but there are these special access schemes where we can actually import drugs for our patients that aren't actually registered in Australia. And so there's two pathways, a SAS-B and a SAS-A. And the cannabis, the products that the prescribers are writing scripts for are all going through the SAS-B, so they're not registered products. They do have to meet the TGO 93 standard, which is a very basic sort of standard of making sure there's no aflatoxins and other chemicals in the cannabis products. So they go through a safety thing and the TGO 93 approved.
So is this a New South Wales Health opinion about the special access scheme, though, in terms of medicinal cannabis in this state? Are you coming to this inquiry with a particular view about the special access scheme, that it is less legal, that it is less safe, that people shouldn't be doing it, that GPs shouldn't be prescribing it? Because that's certainly the opinion that I have taken away from the evidence here from New South Wales Health. Would you like to clarify?
It's not about legal, it's about a regulatory process that we have to ensure that our drugs are safe.
Sure, but you know what this inquiry is about? This inquiry is about people who are taking legally prescribed medicinal cannabis. Doesn't matter which way they get it, it's legally prescribed. So this, whether it's from the special access scheme or whether it's from the one that you mentioned, it's the same though, isn't it, in terms of what we're arguing here today?
Not really, because when drugs are listed on the ARTG, they have a body of efficacy and safety evidence, so it's a much higher bar to get a drug listed on the ARTG. And so because we don't have those products on the ARTG, we have another pathway to facilitate access for patients who need it through the SAS-B. I mean, it would be great.
But are you saying that New South Wales Health doesn't think the special access scheme should exist?
I haven't said that at at all. The SAS pathway is through is a Commonwealth process. The SAS, all practitioners, is just part of our
the relevance according, just in terms of what we're inquiring into today, just to be helpful, what we're inquiring in today is legally obtained medicinal cannabis. So that's via the special access scheme as well.
The reference, I think, to that was to say that there isn't a body of evidence to support its use in clinical practice, so the only way that patients can access it legally at the moment is either through the SASB or through clinical trials. So that's what we're saying. But I think we had to be clear that it's not a drug that is widely used, widely accepted, that there's evidence to support it in clinical use. It's a pathway for us to help our patients when we want to use it but we haven't got a registered product. Does that make sense? Sorry.
And that, if I might say as well, Jenny, is a view shared by the TGA in most of their, on their website where they talk about cannabinoid products. They generally do recommend that people seeking cannabis products are involved in trials and do acknowledge the paucity of data around many of the common indications. So that is, it's not about legality or illegality. It's about the evidence of efficacy and the role in treatment, the place of treatment.
And the special access schemes did come in place, just to be clear. There's a reason they came in place.
We've had them. We use them for other drugs as well. When there's no evidence yet for a particular drug, but as clinicians, we are really struggling to give a cancer drug to a patient that's not available in Australia. We use the SAS pathway so that we can provide that to our patients, but we tell our patients they're not registered products and we don't have the efficacy data yet.
Final question. Oh, yes, Assistant Commissioner, quickly, and then Greg, and then we're done.
Just to clarify, the point about the licence suspend or disqualification was it's 3 months, not 6 months, and just some data. In the period of 2020 to 2021, there were 5,388 penalty notices issued and 4,561 court attendance notices. So there's a favour in terms of a penalty notice over a court attendance notice in terms of enforcement. I hope that assists with that inquiry.
And that was just for THC, though?
No, that's for all drugs.
That's for all drugs, thank you.
Mr Donnelly.
Thank you. Just finally, page 15 of the submission about the possible insurance implications. Like to perhaps elucidate on that. There's 3 paragraphs there that make some comment. Is there anything you'd like to add to what's there, or that essentially reflects what have you sought legal advice on this, or this is an opinion formulated by just thinking about the matter?
I think, and thank you for the question, it was really, the submission's really identifying that there are obviously issues in the CTP scheme, insurance scheme, that would need to be considered if there were changes, as with any changes, that would impact insurance, part of the motor vehicle insurance scheme. So obviously that would need to be considered and factored into any future changes to CIRA's green slip, its CTP insurance scheme.
Okay.
Great. Thank you all for attending today and for your evidence. The committee has resolved that answers to questions taken on notice, I think there were a handful of questions on notice, be returned within 21 days. The Secretariat will contact you in relation to the questions you have taken on notice. In addition to that, committee members may have additional questions that could be submitted to you for a response as well. So thank you all for coming. Thank you.
Thank you.